All right, good evening. Today's June 16, 2020. This is a meeting of the Needham Planning Board. Welcome to all those who are interested in tonight's proceedings. As we've been doing with these meetings since the COVID-19 crisis began, I'm going to begin by just reading a script for this meeting so everybody understands how we're going to proceed and what the ground rules are. For those members of the public who may be watching or listening in, I'm going to quickly just call the roll of everyone here who is member of the planning staff, member of the planning board, or is or may be a presenter tonight for one of our agenda items. So just when I call your name, please respond in the affirmative. Lee Newman.
Present.
Alex Klee.
Present.
Thank you. Jean McKnight.
Here.
Ted Owens.
Here.
Paul Alpert.
Here.
Adam Block.
Here.
For the Spiga matter, George Junta.
Aye.
Lucio Trabucco. Lucio, I think you're muted right now.
Can you hear me now?
Thank you. I can hear you.
Okay.
Marissa Yoki?
Yoko, yes, I'm here.
I'm sorry.
Thank you. Yeah, that's okay, no problem.
For the Heather Lane subdivision matter and the Heather Lane extension subdivision and residential compound. First of all, Attorney Robert Smart.
I'm here.
William Pierciak.
I'm here.
David Kelly.
Present.
And Brandon Lee.
Present.
For our 100 West Street zoning proposal matter, Roy Kramer.
I'm here.
Evans Huber. Evans, yeah, Evans, I think you're muted.
I'm present.
Here we go, thank you. Lee Bloom.
Here.
Ted Doyle.
Present.
Erin Fredette.
Here.
And Louise Giannakis. And there she is. Okay. I'm going to just begin by reading this script. Please bear with me for a couple of minutes. It's now approximately 7:20 on Tuesday, June 16th, 2020, and this is an open meeting of the Needham Planning Board. This meeting is being conducted remotely, consistent with Governor Baker's executive order of March 12, 2020, due to the current state of emergency in the Commonwealth due to the outbreak of the COVID-19 virus. In order to mitigate the transmission of the virus, we have been advised and directed by the Commonwealth to suspend public gatherings, and as such, the governor's order suspends the requirement of the open meeting law to have all meetings in a publicly accessible physical location. Further, all members of public bodies are allowed and encouraged to participate remotely. The order allows public bodies to meet entirely remotely so long as reasonable public access is afforded so that the public can follow along with the deliberations of the meeting. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will allow public comment. For this meeting, the Needham Planning Board is convening by Zoom app as posted on the town's website identifying how the public may join. Please note that this meeting is being recorded and that all attendees are participating by video conference. Accordingly, please be aware that other people may be able to see you, and please take care not to screen share your computer. Anything that you broadcast may be captured by the recording. All supporting materials that have been provided members of this board are available on the town's website unless otherwise noted. The public is encouraged to follow along using the posted agenda unless the chair notes otherwise. I would note on that the original posted agenda has been changed in terms of the order of things. The matters are the same, but the order of things has changed, which I'll review in a second. Before we turn to the first item on our agenda, permit me to cover some ground rules for effective and clear conduct of our business and to ensure accurate meeting minutes. First, I will introduce each speaker on the agenda. After each concludes his or her remarks, the chair We'll go down the line of members, inviting each by name to provide any comment, questions, or motions. Please hold until your name is called. Further, please remember to mute your phone or computer when you are not speaking. Please remember to speak clearly and in a way that helps generate accurate minutes. For any response, please wait until I yield the floor to you, and please state your name before speaking. After members have spoken, I will afford public comment as follows. I will first ask members of the public who wish to speak to identify themselves by name and address only. And once I have a list of all public commentators, I will call on each by name and afford each 3 minutes for any comments. Each vote taken in this meeting will be conducted by roll call vote. And now I will ask for a motion to automatically continue this meeting to our next meeting date, which, Lee, is what date? I think you're muted.
July 7th.
July 7th, to July 7th at 7 p.m. with the same Zoom ID number, if any technical difficulty should arise that keeps us from continuing tonight.
So moved.
Second.
Thank you. Thank you. I have a motion and a second. Any discussion? All right, I'm going to call the roll. I'm going to start with Jean.
Yes, aye.
Paul,
Yes.
Adam,
Yes.
and Ted.
Yes.
And I'm a yes as well. Okay, now I'm going to move to our agenda. The order of our agenda is somewhat different than what was posted, but we will proceed in this order. The first item on the agenda will be related to a request to extend the action deadline regarding 390 Grove Street. Second item, request to extend temporary occupancy permit regarding 1407 Central Ave. Third item will be 100 West Street. Fourth item will be our public hearings, first Spiga and second Heather Lane. Then we'll review our minutes, then our correspondence, if any. Then we'll hear reports from our planning director and board members, if any. And lastly, we will take up our planning board reorganization. That's 8 items on the agenda. So the first item is going to be 390 Grove Street, request to extend the action deadline. Lee, do you want to tell us what this is about, or is George anticipating saying something on this matter?
I'll yield to George if he wants, or I can speak if he wishes.
George, do you have a preference?
I really don't have a preference. I can speak to it, or Lee can speak to it.
Go ahead, George.
All right. So 390 Grove Street, that's a subdivision that the board has been dealing with for a little while now. And because of COVID, it got put over. And we had requested that it be picked back up again and put as an action item on an agenda. But with that, we had to extend the date, both with respect to the hearing and then also with respect to the applicable action deadline. As under the statute, the planning board only has so long unless it's extended. So you've got a request pending to extend that action deadline that goes along with the request to hold a rescheduled hearing.
Okay. Members, any discussion?
George, what's the date that you're proposing for the extensions?
I believe it's through the end of August for the action deadline, and the hearing, the target date for the hearing is the July 21st meeting, I think.
That's correct.
The way it's stated in George's letter is July 21 or the next earliest available meeting of the board.
Are you ready for a motion, Mr. Chair?
Let me just see if there's any other questions or discussion. Not seeing any, not hearing any. Lee, did you want to add anything?
No, that's it. I think that's what we're looking at, a hearing on the 21st and the extension of the action deadline to the 31st of August.
Okay, thank you. Paul, I am prepared to entertain a motion.
Okay, then I move that on the 390 Grove Street subdivision application, we postpone the hearing until July 21, 2020 at what time, Lee?
I don't have a time. Just
Okay.
that date is sufficient.
Okay, and And second, that we extend the action deadline to August 31, 2020.
I have a second?
A second.
Second.
I have a motion and a second. Any discussion? All in favor, I will call the roll. Start with Adam,
Aye.
Paul,
Aye.
Ted,
Aye.
and Jean.
Aye.
And I will record myself as an aye as well. Anything further on that, Lee?
No, that takes care of that item.
Okay, the next item is, second item on our agenda as amended, pertains to 1407 Central Ave. Lee, do you want to quickly bring us up to date on this?
So this is this was the town's project. It's the Jack Cogswell building. We've pretty much closed everything out on this project. We are waiting though for the land court to issue the consolidation plan on the lots, and that is not yet out of the land court. So this is a request to basically extend the occupancy permit on this project until August the 10th. It's anticipated we'll have the consolidation plan out of the land court by that time.
Questions, comments?
Well, considering that the courts are closed except for emergency matters, I'm wondering whether we should extend for a longer period of time, because I don't think the land court will be ready by August 10th.
That's fine. I think if we took it out to the fall, I don't see any harm in that.
All right.
So
Go ahead, Paul.
what do you see? How long can we extend a temporary certificate of occupancy?
We could do it for 4 months.
So that brings us July, August, September, October.
That would be fine.
So I move that we extend the temporary certificate until October 10, 2020, or the next business day, if that's not a business day.
I have a second.
Second.
Discussion? All in favor, I will call the roll again. Adam? Adam, you're muted.
Aye.
Thank you. Paul?
Aye.
Jean?
Aye.
Ted?
Aye.
And I'm an aye. Okay. That's our second agenda item. Third agenda item is 100 West Street. Seeking the planning board's support of a proposed zoning change. This has been on our agenda for at least twice in the past. There are some new materials that have been provided to us just in the last few days by attorneys Huber and Kramer. Evans, do you want to just quickly bring us up to date on what's now in front of us?
Sure, absolutely. So our understanding from the last meeting of the planning board was that the only substantive issue relating to the language of the proposed warrant article had to do with whether or not the uses that LCB plans to put in this building would be allowed as of right or by special permit. Several of the board members expressed a view that they felt it should be by special permit. After that meeting, we conferred with our clients and with Welltower, the owner of the building, and we decided that we would change the proposed warrant article so that those uses are now would be allowed by special permit. So we revised the warrant article and resubmitted it. And so the only changes to what's before you now is that those uses are now allowed by special permit under this the current version of the warrant article. And we would also amend the section of the bylaw that relates to what sections the planning board is the special permit granting authority as opposed to the ZBA, so that we make it clear that under this proposed warrant article 3.15, special permits would be granted by the planning board.
Okay. Attorney Kramer, did you want to add anything?
No, that's the only change, and we would hope that since that was the only issue left over from last time, that you'll be comfortable supporting the proposed warrant articles as written, and to sponsor the the warrant articles in the fall town meeting.
The only thing I would add to that is that obviously we're aware of the concerns that were expressed regarding traffic. And those are things that could be dealt with at the permitting stage now that this would be governed by a special permit.
Okay, so the issue before us, planning board members, is are we prepared to proceed to a vote to support this proposed zoning article as written? And I'm going to open it up for discussion and or motions. So why don't we start, I'll go down the line. Why don't we start with Mr. Owens?
I have no comments or questions.
Thank you, Ted. Jean McKnight.
Yes, on the understanding that the traffic issues that Mr. Huber referred to will be discussed and considered, and there may be additional traffic reports, particularly as to traffic safety at the West Street, Hillside Avenue intersection. I'm satisfied to go forward. However, I'm not sure what we're actually voting tonight. I thought what we'd be doing, assuming we are being asked to sponsor this article, and that's a factual question. I was assuming we were going to be asked to sponsor it. And
That's
I'm certainly,
correct.
Yes.
yes, I am prepared to vote yes, that we do sponsor this article in its current form. But of course, any recommendation on approval would come after our hearings.
Did I say that the issue before us was whether we would support it or whether we would sponsor it? I meant to say sponsor if I said support. That's my mistake. Okay. Paul, comments, questions?
No, as was stated at prior meetings, I have kind of taken an active participation in this process, and I'm very pleased that the proponents have graciously worked with me and made changes that I had suggested, including the special permit. I'm very pleased with the current form of the bylaw proposal, and I'm very willing to have the board sponsor it in its current form.
Thank you. Mr. Block.
Mr. Chair, I'm satisfied to proceed that the planning board should sponsor the article at the fall town meeting.
Okay. I also have no further comment, and I'm satisfied with the way things sit. So if one of the planning board members is prepared to make a suitable motion, I'm happy to entertain it right now.
Well, I'm willing to give it a try. Mr. Chair, I move that the planning board sponsor a bylaw amendment for an Avery Square, correct me if I'm wrong on the wording, Evans, the Avery Square Business District overlay.
No, we're calling it the Avery Square Overlay District.
Okay. Let me start from the beginning then. I move that the planning board sponsor a bylaw amendment to be presented to town meeting in October 2020 for the creation of an Avery Square Overlay District with the form of amendment being the form that is in front of the planning board this evening.
And excuse me, let me just, one point of information. There's a second map change.
Hold on, Roy. Let me just, for the sake of the record, let me just recognize that Attorney Kramer appears to want to ask a question or add a comment.
Yes, thank you. My only comment is to remember that there's a second map change article that goes along with it, and your sponsorship of the overlay district should also be accompanied by sponsorship of that map change article.
Would you accept that as a friendly amendment, Paul?
Absolutely. Do you want me to add the wording to that, or?
Sure.
And that the planning board sponsor the second bylaw amendment that is proposed and in front of the planning board this evening for the map change that would delineate the Avery Square overlay district.
Thank you. Do I have a second?
Second.
I have a motion and a second. Discussion. Jean?
Yes, my only concern is being specific about October 2020. Given that town meetings have been postponed for good reason, and although a date for a fall town meeting may have been set, I'm not sure, it could be postponed. Would it be okay to say a fall special town meeting?
Paul, you okay with that?
I'm absolutely fine with that, yes.
All right, so we'll use that as a friendly amendment. Okay, any other discussion? All right, I'm going to call the roll. I'm going to start with Mr. Owens
Aye.
and Ms. McKnight,
Aye.
Mr. Alpert,
Aye.
Mr. Block,
Aye.
and I am also to be recorded as an aye. Okay. Is there anything further to be done with regard to that agenda item 100 West Street, Lee, or is that all we need to do at this point?
At this point, I think that's it. I'll put it on the agenda for the next meeting. We can vote to refer it. This article then has to go to the selectmen and be referred back. So we'll come up with the schedule in terms of the hearings on this, and we can take that action at the next meeting.
Okay, then that concludes this agenda item. I'd like to thank Attorneys Huber and Kramer, and I would also like to thank Lee Bloom and Ted Doyle and Erin Fredette and Louise Giannakis for your patience during these several hearings. We look forward to proceeding with this. Thank you very much.
As do we. Thank you very much as well.
We appreciate your time and patience.
Thank you all.
Thank you.
Thank you. Bye-bye.
Okay, so that's what is now the third agenda item. Now we're going to move to our fourth agenda item, which is our public hearings. And the first of the public hearings is going to be a major project site plan review regarding Spiga LLC at 18 Highland Circle, Needham, which is also that's the location of the subject property. So as to that item, we I believe are going to be hearing presentation first by Attorney Junta. Is that right?
That's correct.
Please proceed. Floor is yours.
All right, thank you, Mr. Chairman. George Junta Jr. appearing on behalf of Spiga LLC and the Spiga Restaurant. And it's a little bit of a misnomer to say that this is a site plan special permit review, because it's actually a little bit less than that, but I'll get to that in a minute. So the board may, some of the board members certainly are likely to recall, Spiga Restaurant is located on Highland Circle over sort of the outside of 128. It's behind Highland Avenue, sort of right before the Newton line. And it technically consists of two separate lots. One lot is where the restaurant building proper is located. And then the other lot is the parking area. Now, it's significant that there are two lots, because while the landlord owns the fee in the restaurant building lot outright, the parking lot is actually held under a 99-year lease, which continues until 20...
Can you hold on 1 second, George? Just hold 1 second. I just got a text that we have a hand raised.
Yes, the hand is now down, but it was up for a little bit. So I just want to let you know that Frank Holmes had his hand raised. Let me see. Marty, shall I allow him to talk?
This would not be in a moment unless it's for one of the items that's already passed, if we missed them. But I don't want to interrupt George's presentation any more than we already have.
Okay, well, whatever I don't know what it's about.
I don't see that person listed. Is that person, hold on.
He's still here. He's put his hand down, so maybe, oh, his hand is back up.
He's on as an attendee. If you look at the participant screen, Mr. Chair.
I see it. I don't see a hand up next to Mr. Holmes right now.
It went back down again. It's up again.
Now it's up.
All right. Can you recognize Mr. Holmes? I simply want to hear from him as to whether this relates to the current matter before us or a prior matter that we've already dealt with.
Sure.
Mr. Holmes?
Okay, Mr. Holmes, you are on, but you're muted, so you'd have to unmute yourself.
Can you hear me?
Yes.
Okay, I apologize for the interruption. I was only trying to figure out how to mute and unmute myself. I didn't actually mean to raise my hand. I am interested in this matter, though, and but at the appropriate time when I'm recognized, I could speak then. I apologize again for the interruption.
That's fine. Thank you very much. Okay.
Thanks, Marty. Sorry about that.
Thank you. And Attorney Junta, sorry for that, but you know, this is, everybody's trying to figure out this technology, so we're doing the best we can. Go
It's a
ahead.
learning experience all the way around.
Yep.
Yep. All right. So, the second lot with the parking is held under a 99-year lease that won't expire until 2081. So while, you know, looking at it sort of from a practical standpoint from the outside on the ground, you'd never know. Technically, the two lots are in separate ownerships. And as a result, the lot line between them, which is basically runs right along the edge of the parking area, right near the actual building, is an actual lot line. So Spiga is now proposing to make some changes to the building. And one of the things that they need in order to accomplish those changes is a reduction in the side yard setback. Because that lot line between the two lots is an actual lot line, there is an applicable side yard setback that comes into play. And that would normally be 10 feet in this district. But Spiga is asking the board to exercise their discretion and grant a special permit to reduce it down to 7.5 feet. Now, that's what the requested relief is. And the reason for the requested relief, if I can share my screen.
Please.
Okay. So you can see here, this is lot B here. This is the existing building where the restaurant is located. This is lot A over here. This is the parking lot. And then this right along here is where the property line is. So Spiga is proposing to do basically two pieces as almost one sort of addition. The first piece is this section right here, which you see says vest for vestibule. And this would be an actual fixed construction addition, an extension of the building, you know, with sort of brick and mortar, so to speak. And then this piece here that says tent proposed addition number 1, this is a fixed location tent. So basically it's a fixed scaffolding framework that would go in and be permanently set, but it is an actual tent type of covering and sides so that in the good weather, it can all be rolled back and opened up. And then in the bad weather or in the shift of seasons, can be closed back up, and then heaters can be put in and it can actually be used, if not year round, close to year round. So this being that lot line in question, normally there would be a 10-foot setback here that would intrude in. So Spiga is asking for a special permit from the board to reduce that to 7.5 feet, which would allow for this line right here. I just want to comment, you'll see this little bit juts out. So we're here before the planning board really just for the special permit to reduce the setback. The rest of the relief that we need is all from the Board of Appeals. It's a quirk in the way that the bylaw was written with respect to the mixed-use 128 zoning district. The planning board has exclusive jurisdiction over this special permit reducing the setback, but all the substantive relief for the restaurant, increase in seating, is with the Board of Appeals. And as a part of that, we are requesting a variance to be able to do this little piece right here, to be able to do the vestibule, to create a handicapped compliant shelter, basically for patrons coming into the restaurant. This is where the door is to the restaurant. So, stop that share. All right, so the restaurant was originally permitted in 2005. It's been in operation ever since. However, it's been sort of in fits and starts proposed to expand. So in 2008, there was a permit that was voted approved, but never actually issued through a quirk of circumstance. Then in 2015, there was a similar proposal that also involved an addition on the opposite side of the building. That was approved by both the Planning Board and the Board of Appeals, but that was never acted upon. So as a result, this is sort of fresh out the blocks, a new application. So as I indicated, we're asking the Planning Board for a special permit to reduce the setback, and the bylaw specifically says that the grounds for that are that due to the configuration of the property, that the proposed reduction in setback won't be inconsistent with or at odds with the general purpose and intent of the bylaw or the district. So we would propose that that basically reducing the side yard setback down to 7.5 feet from the current required 10 feet allows for the installation of this tent area over what is essentially right now an existing patio area, which then provides for at least 3 season, if not year-round seating, which benefits the patrons of the restaurant, it benefits the town by having this sort of flexible and open air seating. Now, obviously these days with COVID, open air seating is a huge part of any restaurant. So, you know, it's most pertinent now, but even going forward, hopefully once COVID drops off our radar screen, it will be very nice to have a restaurant that can have this sort of arrangement where they can have it open in the good weather and then closed in the not so good weather. So we're asking, again, for just a special permit under section 4.9.3. And then this coming Thursday, we're actually scheduled to appear before the Board of Appeals to present before them and ask for special permits with respect to additional seating and the variance for the little bump out of the vestibule. So any questions?
Marty, you're muted.
Thank you. George, is anyone else with you like to say anything tonight, or is that going to be your presentation?
Well, I think so. You've got Marissa Yelke and Lucia Trabuco, and I'm not sure if they want to say anything, but they're certainly available to answer questions as well.
Well, if you'd like to say something, now would be a good moment.
Okay. So Marisa Iocco, I'm one of the owners and representing Francesco Iacoviti as well. The only thing that I want to say, as everybody knows, we're going through a really, really tough time with the business. And hopefully with the patio that everybody's invited to come and visit, then we adjust with brand new plants, and you know, it's beautiful. And eventually the tent will be able to hopefully have some more customers even when summer is ending. So this will be helpful for us. It will request a big investment, and it's not our building, but we'll do it anyway because it's the only way that we think we can survive. Just offering all year long more space for people than they want to sit outside. That's the only thing that I would say.
Okay, thank you.
Thank you.
Okay. I'm going to turn to the members now to pose questions, comments, etc. I'm going to start with Mr. Block. Adam, I think you're muted.
Thank you, Mr. Chair. I have a couple of questions. And certainly I understand that this is not an easy time for restaurants. And I know that Massachusetts in particular is taking a very concerted effort at opening up, and I can only imagine how challenging it is as an operator. I wanted to get a little clarity on a couple of things. Let's say a year from now, at some point, we hopefully will have coronavirus behind us. Do you anticipate maintaining the structures and the vestibule after we return to the new normal?
This is Lucio Trabucco. The reason for the vestibule is actually, as George stated, was for handicap access. And also there's a thing that the door is flush. The existing door right now is flush with the exterior wall. So in the inclement weather, when you open the door, there's a lot of people don't want to sit. I don't know if you ever been to a restaurant, but there's a row of seats that people don't want to sit because it's really cold. So there's two reasons why to put that vestibule is very important to this.
In fact, we are at the tent.
And also the tent. In the past, they also rented a tent. Right now they want like a permanent tent, a permanent structure, so they can use it for, again, as we stated, for summer use as well as hopefully in the winter use as well. But the vestibule area is very important because it creates an airlock to the structure.
Yeah. And if I could just clarify, Adam, the vestibule piece is actual fixed construction, like a regular addition. It's the tent section is only that's obviously the tent piece, the canvas or whatever the covering is can be moved around. But even on the tent, the framework is going to be bolted, basically permanently bolted down.
So I understand that part, and I certainly understand the need for a vestibule and the accommodation that provides for handicapped individuals or disabled individuals. Is the tent part intended to remain a permanent fixture, so to speak, after coronavirus? It is?
Yes.
Okay.
Yes.
Yes. And in fact, so when I referenced the approval from 2015, at that point, basically where this tent is proposed, it was proposed for a physical addition at that point, which would have then closed this in and would have made it all interior seating. The tent, while not only being a little less expensive to construct, also allows for the open air seating in the good weather. So it kind of gives you a little bit of the best of both worlds in terms of covered seating in the bad weather and also open in the nice weather.
Yeah, I understand that plan well. And then to turn to a couple of technical matters, I look now at the site plan, and there are a few things that stuck out for me, and I'm going to admit that I'm new to the planning board too, so I appreciate your understanding of perhaps my naivete here. When I see this on the zoning table, the side setback it looks to be required at 10 feet. It's existing at 0.9 feet. Proposed to be 0.9 feet. It's pre-existing. I understand that. And now the proposed addition, again, has required 10-foot setback. The existing is not applicable, and the proposal is 2 feet. So is it a total of 2.9? Is a total of a 2.9 foot setback?
Okay, so if I can share my screen again, I think I can clarify that.
I appreciate that, because I understand that you're looking for a reduction only to the 25% from 10 to 7.5 feet.
Right. All right. So the 0.9 is over here on this side.
Yes.
So that's where it's 0.9, and that's obviously not being changed or affected.
Mm-hmm.
The 2 feet is just right here. So when we do these zoning tables, we're always doing it to the closest point. So technically, right, so the setback all along here is 7.5.
Yes.
And then it's only this little triangle kind of that's in there that's 2 feet at the closest point.
So is that additional relief being sought, or it's satisfied by the 7.5?
So the 7.5 satisfies if you extended this line here, you extended it all the way up to the building, it would satisfy that. This other little triangle that extends past that,
yes,
that we need relief from the Board of Appeals for.
Oh, I see. Okay,
and that's the variance we've asked for, and will be before them on Thursday.
Thank you for clarifying it. The last thing that I noticed, this is not really so material, but at the parking table under the existing 54 seats year round, it's 18 spaces are required, And then under proposed, it's still 54 seats year round. You know where I'm going.
That's a typo in the plan.
Okay.
Yep.
Okay. I wasn't sure what was up. I played around with some math at around 1:15 this morning, but you solved it, and I'm grateful.
Great.
I
Yes.
I have no further comments or questions.
Thank you. Just to clarify, the typo exactly is what, George?
So here where it says 30 spaces, I think that might have been from when the table was from a prior version of the plan, when it was the proposal from 2015. But the requirement for restaurants is 1 parking space for every 3 seats. So you can easily do the math, and you can see that the 54 divided by 3 is 18, not 30.
So the 30 should
So
be
this 30 is an error.
30 should be 18 plus the 11 for the seasonal seating gives
Right.
a total of 29, which is correct.
Right.
Okay. Okay. Adam, did you have anything further?
No, Mr. Chair, I'm satisfied. Thank you very much.
Okay. Mr. Owens.
So this is the result of a quirk in the fact that the parking lot is controlled under this long-term lease, and that if both properties were owned, the issue of the 10-foot setback would not exist. Is that correct?
Absolutely.
Okay. I'm all set then. Thanks.
Thank you. Ms. McKnight.
Yes, and Mr. Chairman, I have some comments about the decision. Is this the time to make them, or is it better to make them later?
Why don't we hold on that aspect, but happy to hear any other comments or questions, but we'll come back to you on that later.
All right. I do have a question about the parking spaces. I know that the tent will make it very difficult, but it's already difficult to access certain parking spaces. I'm looking at the string of parking spaces, from number 17 to number 28 along the Highland Circle frontage.
Hey, Gene, can
But I assume,
I just ask George if he would share his screen to show us that plan again so everyone can see it while you speak? Go ahead. I'm sorry, Gene. Please go ahead.
And I assume that parking, that person's parking come right in off Highland Circle. They don't enter a parking lot on the premises and then go into the parking spaces there. They go in and out off Highland Circle. This is something that's quite prevalent in this area, in this zoning district, as well as the Highland Commercial Zoning District, and something that the planning board has its eye on eliminating. But it seems as though it's already an issue. I don't know if it necessarily makes it much worse, but if you could comment on how drivers do get into those parking spaces, please, Mr. Junta.
Sure. All right. So spaces 15 wrapping around the front of the properties, so space 28 over here. These are all head-in spaces where people drive through Highland Circle and then pull in, then they back up and then they leave. Now, and they've been there since at least when the restaurant opened in 2005, if not well prior before that. Certainly these spaces were there. I don't know that these spaces were marked as spaces, but basically this was all asphalt in 2005 and sometime before that. So the spaces themselves have certainly been around for a long time. There haven't been any noticeable or significant issues in the 15 years since the restaurant's been in operation with these spaces. And where the tent is going is basically where the patio is now. So there won't be any real, different meaningful or material impact to these parking spaces. So you know, we basically look at this as an existing condition. You know, in a perfect world, generally you don't like to have head-on spaces, but it has worked fairly well here. And one of the other things to keep in mind is Highland Circle is actually a private way. And although there are some office buildings on Highland Circle, you know, generally Spiga, the restaurant, is busiest at night when those buildings tend to be empty. So really in the evening, most of, if not all the traffic coming down Highland Circle is for the restaurant. And then during the day, you know, there's a little bit more, but even during the day, there's not a ton of traffic on Highland Circle, as I can certainly attest to, having been there myself many times during the day.
Okay, thank you. Second question. Our public safety officers have commented on the need for concrete barriers between the parking area and the tent. Now, are the things that look like balls, black balls, are those the line of arborvitae you're speaking of?
You're talking about this line here?
Yes.
Yes, yes.
So that performs the function of at least a visual barrier, though I suppose a car could crash through it. But more importantly, at the end of the parking spaces we were just speaking of that are accessed off Highland Circle, are there concrete barriers, good, strong ones at the end there? There was nothing said in the decision about complying with that condition that the police and fire chief wanted to see.
I don't believe there are any right there now, but certainly, you know, safety is obviously a concern that everybody would share. So that's something that we can do, is put concrete in there. I think, I'm not sure if it was the police that referenced either concrete barrier or concrete planter, but either way, that's something we can certainly add in.
Okay, I just don't want that to be forgotten. And then I noticed a change in the wording of the decision, and I'm not talking about the wording, but so much as the concept, so I'm raising it now. Under what circumstances would you erect the tent but not construct the vestibule?
Really, in only one circumstance, and that is if the Board of Appeals does not grant the variance that we've requested for the minimal intrusion into the setback area.
I see. Okay. All right. Those are my questions. Thank you.
Thank you. Mr. Alpert.
Yes, George, I'm confused about exactly the legality of what we're voting on here, because we're dealing with two parcels. It's described as parcel 7 is the parcel that the building is on, and parcel 8 is the parking lot building, the parking lot. Are we voting to reduce the side setback from 10 to 7.5 on both parcels, or just on parcel 7?
Just on what's lot B on the site plan, just the lot that has the building on it.
Okay. I'm not sure that that's clear in the decision, but you know, I'm fine with that. Also, on that lot, on lot B, I think what we're voting is to reduce the side setback for the entire lot. And so my question is there another side lot line that is being affected by our reducing this? And I may have no problem with that, but I just want to be clear on whether or not there's only one side lot line, which is the one that we're dealing with, or whether we're actually reducing the setback from 10 feet to 7.5 feet for some other lot line that might be on the property.
So there is another side lot line, and I'll share the screen in just a minute so you can see that. But we're only asking for it on the one side.
Okay.
All right. So we're only asking for it on this side here. All right, because the addition's only on this side. There's this side lot line as well. And obviously on this side, I mean, the building is it's less than a foot from the line back here. But but we're not asking for the relief on this side.
What is on the other side of that lot line, George?
So there is there's a structure on that side. I think it's an office, like a small office, basically it was a house, but I think it's been converted to an office that has access, I think, off of Highland Circle, either directly out this way or maybe out that way. I can't recall.
And how far from the lot line is that house? Is it close to the lot line, or is it set back quite a bit?
Let me see. Let's see if I can find. It's somewhat close.
So what I'm getting at is that if it turns out that the wording of our decision winds up affecting both lot lines by reducing it to 7.5 feet, I'm probably okay with that anyway, as long as we're not really impinging on the house by allowing an extra 2.5 feet for future expansion on that lot line, because you've been granted relief tonight that by the wording of our decision is not applying only to the solely to the one lot line that you need the relief for tonight. Because I wasn't focusing in on that before, and now my reading of the decision, I'm not sure that it's worded with enough specificity to just grant 7.5 feet for that one lot line. And I'm saying, well, that may be okay. I'm also not clear from reading it that it applies only to lot 7 and not to both lots, but that may not be an issue either, because it looks like lot 8 doesn't really abut anything on the side lot line of significance.
Now, I don't know if it'll be helpful, but I can share the assessor's map that shows the structures.
Yep, that would be helpful.
All right, so this is Spiga here.
Yep, that's lot 7.
All right, this is the parking lot.
Yep.
This is frame shop.
Yep.
This is insurance, the insurance company, Barry and Farrell. This is it Mike's Italian? I can't remember the name of the Italian takeout location.
Yeah.
Relatively new. And this is the one that you were asking about. So you can see it's relatively close to the lot line here, and then it's open there.
Okay.
Yeah, and I think the door is actually on this side.
Yeah. So it's possible that we're giving an extra 2.5 feet on that side. It doesn't look like that extra 2.5 feet, if you did a future expansion over there, would greatly impinge on the next door neighbor. And similarly, I think we want to make sure that our decision is clear that we're only granting the relief on lot 7 and not on both lots that are controlled by the parties.
Okay.
Those are my comments, Mr. Chair.
Thank you. To me, I second Paul's last comment. We do want to make sure that. I also want to second Jean's comment as to the Jersey barriers. I don't think I saw, maybe I missed it, clear reference to the fact that there will be barriers erected for safety purposes as recommended highly by our public safety officials. Did I miss it, Lee, or is it not in there?
No, it's not in the decision. I thought that was going to be captured through the ZBA because we are conditioning our permit on the site plan relief that the Board of Appeals is going to be granting. So I assumed that the ZBA was going to capture all those issues of the safety, the number of seats, those locational issues, and then ours permit was really only dealing with the location of the structure relative to the property line and not all the operational issues under the underlying permit.
I see. So let me think about that for a second as to whether
Mr. Chair,
we could leave all that to them. Adam, yes?
Exhibit 9 of the decision does reference correspondence with our public safety officials. So if we're not referencing it, if we're referencing it as an exhibit, and we have correspondence from our public safety officials that are requiring safety barriers, let's call them, does that not satisfy us and enable us to proceed as is?
Well, I think typically we would recite any conditions or restrictions right in our decision.
Typically, what we would do is we would ask for a plan modification as part of our decision to show how that was going to be complied with.
Right.
It's a little muddled because our jurisdiction is really only on the setback issue, and they have control over all the operational issues on the site.
And so here's my question, I suppose. Would we be comfortable if we don't address that in our decision, leave it to the ZBA to address it, and then find that they do not adopt that requirement in their decision?
What if we say, you know, to the extent that the zoning board hasn't addressed it and it's within our jurisdiction, that we, this acceptance is conditioned upon the erection of appropriate safety barriers required by public safety officers.
Something along those lines, I think would help. Yeah, Jean, go ahead.
I don't see why we wouldn't put in that we want to see the plan modification to show these safety barriers as requested. And presumably the Zoning Board of Appeals will put in a similar condition and we'll be both looking at the same plan. I don't see why that's burdensome. And
I think Jean's right. I think it could be handled that way through a plan modification, and then it satisfies us that we've had addressed those safety issues, and the ZBA will just have their decision be compatible with ours.
George, did you have any comment on that?
Yeah, I didn't, but I think Lucio does.
Yeah, can I make a suggestion? Instead of a Jersey barrier, because we're talking a restaurant, I mean, it would be ugly to see Jersey barrier in front of the main door. What about a curb stop, a tire stop?
No,
Like parking lot.
I think you'll have a hard time satisfying the fire chief with that. I think when seating is put out into a parking lot area, there's a concern about somebody, being hit by one of those cars. And there's been a number of accidents that have happened where people have driven from a parking lot into a seating area outside. And he wants, or has communicated at least, that he wants to have some strong physical barrier that will prevent a car from actually driving into the area where the outdoor seating is when it's adjacent to a parking lot.
Yeah, we
Go
ahead.
I'm sorry. I understand that, but I mean, again, Jersey barrier in front of a restaurant it's not an appealing sight. So I was trying to come up with something that would, that'd be less, intrusive than that.
I think, if I may, I think the fire chief, I think specifically referenced concrete barrier, but I think it was the police lieutenant, I think. I think his comment referenced a concrete barrier or planter, and the idea being just as long as it's something concrete that's going to be strong enough and physical enough to stop a car. So I think.
Let me just say this. I don't think we have to get into the weeds on this. I think what we do need to do is say that call it a security barrier, has to satisfy the fire and police chief. It's not really our call. They're most concerned about it, and I've heard their concern in other contexts as well. If they're satisfied by what you propose to put up, I think we ought to be satisfied by it. If they're not, we shouldn't be. It's really that simple. That's the way I look at it. George, I don't think you have an issue with that either. I mean, they're the ones that have to be concerned about that.
Marty?
Please, Mr. Owens.
So my comment is, it doesn't need to be a Jersey barrier. I mean, there are lots of parking barriers to protect the people sitting at the table that can be attractive looking, whether it's a planter or whatever it is. I think if you go downtown, now that we live in this post 9/11 world, there are lots of of barriers at office buildings that are designed to prevent trucks, for example, getting too close to the building. So I think that there are probably words that we can find that say, you know, parking barriers that are, you know, as you say, satisfactory in terms of their utility. That doesn't mean they have to be ugly concrete Jersey barriers.
As long as they satisfy our safety experts, the fire chief and the police chief, it's fine with me. I mean, it could be, you can do bollards. I don't know. That may satisfy them. And those can be, I wouldn't say attractive, but they don't have to be unattractive. That's the kind of verbiage I would stress. All right, any other comments or questions from board members? Not here.
Mr. Chairman, are we going to vote tonight on the decision?
I believe if we're prepared to do so, I think we probably are, yes.
All right. Then, yeah, I'm satisfied. Don't have any further questions. And I do have a comment when we move to the decision.
All right, well, I think first order of business then, unless I'm mistaken, is to close the hearing.
No, I think there are, I think we need to recognize the comments that we've got formally for the record. And to see if there's anybody in attendance that wishes to be heard on this application.
All right, well, let's do the first thing first, which is to read any additional documentation into the evidence. And I know there were some things sent to us within the last couple hours before this meeting started, which I did not print out. I don't have it in front of me. Lee, do you have those documents? Can you list them for us?
Yeah, so we have basically a memorandum from the Board of Health that's dated June 9th, 2020. We have an email from the Fire Chief, Dennis Condon, which is dated 6/20, 6/10. And then we have another email from the Police Chief, which is dated today's date.
Okay, thank you. So let us turn to the public comment section of this presentation now. I'm going to ask if there are any, what we call attendees, any members of the public who are present and would like to be heard. Please hit the raise hand button. And I see two at the moment. I see Mr. Frank Holmes, and I see someone recognized as Maria. I don't have a last name. Is there anyone else who would like to be heard on this? Okay, let me then start with Mr. Holmes. I'd like to recognize Mr. Holmes for public comment, and we are going to try to impose a 3-minute period for your presentation. Please go ahead.
Okay, thank you again. And again, I apologize for earlier. I do have a couple of questions. Firstly, I was a little bit confused as if the planning board here is voting on the setback issue, but I also heard that the ZBA is as well. So just a matter of, I guess, process here. Is the decision that the planning board is making strictly on the setback?
This is the chair. The answer is yes.
Okay. Second question I have is looking at the site plan. It looks as though the site would be one parking space short with the additional seating that's proposed. So maybe this is then a question for the ZBA. Or is that pertinent to the proceeding tonight?
Well, I'm happy to let Attorney Junta respond to that.
All right, so with respect to the zoning relief being granted, that's not a part of what's before the planning board this evening. That is exactly a part of what the Board of Appeals will be reviewing when they take this up. The number of seats is within sort of their purview as a part of the overall approval of the restaurant.
And will the number of parking spaces, will you be seeking a waiver on that from the
Yeah,
Board of
yes, we're
Appeals?
seeking a waiver of one space.
Okay.
Mr. Holmes, do you understand what that means?
I do. Thank you. One last question. Is that also going to be a Zoom meeting that is open to the public? Because not to say that a public notice wasn't sent out for it, but we got one for this planning board meeting, did not get one for the zoning board meeting, or at least that I'm aware of.
Lee, do you know the answer to that?
Yes, it is planned as a Zoom meeting. And notices, I believe, were sent to abutters under the requirements of 40A. So you should check with the ZBA staff person, Daphne Collins. She can probably send you another copy of the notice if you need it.
And also, I'll just add that if it wasn't mentioned, that their meeting is Thursday night for that hearing. And I can give you my email address right now and make sure that you get that Zoom webinar ID number. My email address is aclee@needhamma.gov. So just reach out to me and I'll get you the information you need.
Thank you very much, Mr. Chair, and have a great night.
Thank you. Mr. Holmes, I probably should have asked you, can you just identify your address?
Oh, yeah, sure, absolutely. So my family owns the property at 73 Highland Avenue, which is currently operated by Chef Mike's.
Okay, thank you. Okay, the next attendee who would like to be heard is shown on my screen as just Maria. I would ask if, Maria, if you could identify yourself by your full name and address to begin.
Sure. Can you hear me?
Yes.
Okay, great. My name is Maria Iriti, and I'm in a butter to the property. I own the property at 21 and 35 Highland Circle, and I'm just here in support. I think it's a wonderful plan that they have, and I think it will be a big improvement. And I did get the legal notices to both meetings as an abutter.
Okay, fair enough. Okay, well, thank you. Thank you both. Is there anyone else shown as an attendee, member of the public here who would like to be heard at this time? Okay, I don't see any other hands raised. Okay, Ms. McKnight.
Yes, I have a follow-up question to Mr. Holmes' comment or question. I want to make sure I understand, and I'd like to ask Mr. Junta. I understand that a waiver is sought for parking because you're having a certain number of seats that require a certain amount of parking and you need a waiver. But it seemed that Mr. Holmes was saying you are losing an existing parking space. And I didn't see that myself on the plan. Is this property losing an existing parking space?
No, it is not.
Okay, thank you.
I think I'm not sure. I mean, we are asking for a parking waiver of one space, and that's because with the total number of seats that we are requesting now, we're just one space short. But there's no change at all to any of the existing parking areas.
Thank you.
Okay, any other questions, comments from any members of the board? Okay, I think the next order of business is to close the hearing. I'll entertain that motion.
Mr. Chair, I move to close the hearing.
Could I just interject? It's Alex. I'm sorry. Everyone's hands were lowered, but Maria's hand is back up. I don't know if that was accidental, but I just wanted you to know before you close the hearing.
Okay, Maria, if you can hear us, do you know how to take your hand down?
No, I did raise it again. I wanted to say at some point I did put in a lease with Spiga for a parking space that they could use at 21 Highland Circle. And if that would help them, I'd be willing to honor that lease that was in place several years ago.
All right, let me just say it with regard to that. I think that's a matter that if you're going to be attending as as an interested party on Thursday night with the ZBA, that is maybe something that you should raise at that point, and perhaps you should talk to Attorney Junta to coordinate.
Okay.
All right, thank you. Okay, so we have a motion from Mr. Block to close the hearing. Do I have a second?
Second.
Discussion. All in favor? I'm going to start with Mr. Block.
Aye.
Mr. Alpert.
Aye.
Ms. McKnight.
Aye.
Mr. Owens.
Aye.
And I am an aye as well. Okay. Discussion as to the decision.
Should we discuss the decision, or should I make a motion to grant the relief requested? What's the proper procedure there, Lee?
Well, we could start with the grant of relief, or if the decision looks okay, you could simply adopt the decision and the relief therein
Okay.
as your motion, either way.
I have comments on the wording of the decision.
Okay, go ahead.
Or should I make them now? Okay. The findings and conclusions, paragraph 1.2, is confusing in the way it refers to parcel 8, parcel 7, and lot A and lot B, because it doesn't tie them together. All it needs to do is say parcel 8, comma, lot, or in parenthesis, lot A on plan, or a specific reference to exhibit 3, and the same thing on parcel 7, lot B on plan, because it's very confusing about what is being referred to in that paragraph when you have both parcels 7 and 8 and lots A and B.
Okay.
Lee, did you get that?
Yep.
Okay.
And the decision that we, I mean, the question and answer that helped me to understand how the zoning board of appeals is going to be dealing with the 2 feet, and we're, after we deal with the 7.5 feet. I know I understand it better, but I think with regard to the description of that issue, and I think it's paragraph 1.7 and 1.8, that should be made more clear, that because otherwise you look at the plan and you say, wait a minute, it's 2 feet, it's not 7.5 feet. I just for some clarity and something said about how the petitioner is seeking relief in that regard from the Needham Zoning Board of Appeals.
Do you have specific wording, Jean, you want to propose?
Oh, I'm afraid. I'm sorry, I did not write something out.
Okay.
And it's kind of hard to make it up on the fly.
Right. No, I understand.
I think we can vote the decision though, because I don't think the wording is really controversial. It's just a matter of clarity. Just if I hope others agree, I don't want to delay this matter.
Right. Any further comments?
Oh yeah, the condition on the concrete barriers along the lines that Lee discussed should be added. The reference to a plan modification.
Okay. All right. Any, before we proceed to any motion, are there any further comments on the specific wording of our proposed decision? Yes, Mr. Alpert.
Yeah, so I think I'd like to get clarity that we're only reducing the side setback for that one side lot. And I think we can do it, we can certainly do it in paragraph 1.8.
Last sentence.
Which is only 2 sentences. It says, accordingly, in connection with the application, the petitioner seeks approval from the planning board for the reduction of the side yard setback by 25% from 10 feet to 7.5 feet. I think we should say there, for the reduction of the side yard setback for the lot line between lots 7 and 8 by 25% from 10 feet to 7.5 feet. I think that better clarifies that that's the only place where we are reducing. And so we're not reducing the other sideline. Actually, what we're doing is reduction of the side yard setback for lot 7 with regard to the lot line between lots 7 and 8.
I think that's the better wording.
Yeah.
Although I think it's referred to earlier in the decision as parcel.
Parcel 7, okay.
Yeah,
Parcel,
and even in that paragraph, it's referred to as parcel.
Yeah. And Lee, I don't know whether there's another paragraph in conditions and limitations that should have, I guess in 3.0.
Yes, I think through that the language in that could be kind of developed to mirror what you just did in paragraph
Yep.
1.8.
Yep, in 3.0. And I think that will take care of the concerns that I expressed before. Yep, those are the two places to make that change.
Okay.
That okay with you, George? Thank you.
I saw a nod of the head. I'll take that as a yes. Okay.
All right, I forgot I was muted. Yes.
Okay. Any further comments on the details of the proposed decision by board members? Okay. So I'll entertain a motion.
I move that we approve the decision dated today, June 16, 2020, regarding Spiga LLC, the property at 18 Highland Circle in Needham, application number 2020-01, with the changes made to the decision as discussed at this meeting.
Do I have a second?
Second, but I think we need a second motion to actually grant the relief.
Yes.
As worded
Oh,
in the
I'm sorry, I thought we had done that. All right, you're right, I'm sorry.
And actually, I think within that, we need to add the language that I'm proposing about specifying the lot line between parcel 7 and parcel 8. So Gene, would you like me to make that motion? So I can word that in there, or do you want to make a crack at that?
Paul, why don't you give it a shot?
Okay, so.
I'll take my motion back and start over again, sorry.
Okay, so I move that we grant the requested special permit under section 4.9.3 of the Needham zoning bylaw to allow the reduction of the side yard setback for the lot line for parcel 7 referenced in the special permit request for the lot line between parcels 7 and 8 by 25% from 10 feet to 7.5 feet, subject to and with the benefit of the plan modifications, conditions, and limitations.
A second.
Discussion. Lee, did you get all that?
Yes, I have it.
Okay,
And-
Gene, discussion.
And that would include the other site changes we discussed?
I believe so. Paul? Is that the intent of the motion?
What other site change? Oh,
Slight change, paragraph, the lack of clarity in parcel references in paragraph 1.2.
I think that will be covered by the second motion to adopt the decision with the amendments that we discussed.
So you want to,
You want me to make that motion also?
well, let's do it one at a time. You want to proceed with the successive motions. Let's take it the one that you've set forth first. Any further discussion on the motion as stated by Mr. Alpert and seconded? All right, I'm going to call the roll. I'm going to start with Mr. Owens,
Aye.
Mr. Alpert,
Aye.
Mr. Block,
Aye.
Miss McKnight,
Aye.
and I am also in the affirmative. Next motion, Mr. Alpert, you want to go ahead?
So I move that we adopt the decision. I've got my pages all mixed up here, so here we go. That we adopt the decision for the Spiga LLC 18 Highland Circle application number 2020-01 as presented to us and with the amendments previously discussed at this meeting.
Do I have a second?
Second.
Motion and second made. Do we have discussion? Hearing none, I'll proceed to the vote. Call the roll. I'm going to start again in the same order. Mr. Owens,
Aye.
Mr. Alpert,
Aye.
Ms. McKnight,
Aye.
and Mr. Block,
Aye.
and I'm also in the affirmative. Lee, is there anything further on this matter?
No, I think that closes out this matter.
Okay. All right. I'd like to thank Mr. Junta and our owners and operators of Spiga LLC. We wish you the best of luck. We hope this helps you. Everybody I know is sympathetic with all the restaurants, and we wish you the best of luck.
Thank you very, very much, everyone. Thank you.
Thank you.
Thank you.
Thank you. All right. Next matter is our second public hearing of the night. This is a request for definitive subdivision approval on property located at 764, 766, 768 to 768A and 768B Chestnut Street in Needham, to be known as the Heather Lane Definitive Subdivision, as well as a proposed additional definitive subdivision and residential compound on one of the lots within the first definitive subdivision. This one to be known as the Heather Lane Extension Definitive Subdivision and Residential Compound. This is all on property located at 768 to 768A Chestnut Street in Needham. And a request has been made that we hear all of this together and we vote, we'll leave separately.
Mr. Chairman, I hate to interrupt, but I just realized that we forgot to waive the reading of the notice on the Spiga application. Are we too late to make that motion, Lee?
So let's do it.
Better late than never.
Yes, I move that we waive the reading of the notice in the application for Spiga LLC.
Before we do that, why don't we start with a motion to reopen that matter and then go to that motion?
Okay.
Go ahead.
I move that we reopen the application for Spiga LLC. I think that says it.
For the limited purpose of?
For the limited purpose of waiving the reading of the notice.
Which we
Second.
forgot. We have a motion and a second. Any discussion? All right, all in favor? Mr. Owens?
Aye.
Mr. Block?
Aye.
Mr. Albert?
Aye.
Mr. McKnight?
Aye.
And I also vote aye. Thank you for this, by the way, Paul. Now that we've reopened the hearing,
Mr. Chairman, I move that we waive the reading of the notice for the application from Spiga LLC.
we have a second.
Second.
Discussion. All in favor? Mr. Albert?
Aye.
Ms. McKnight?
Aye.
Mr. Block?
Aye.
And Mr. Owens?
Aye.
And I also am in the affirmative. Now, I guess we have to reclose the hearing, do we not?
I move we close the Spiga LLC hearing.
Okay.
Second.
We have a second. Okay, discussion. Hearing none. All in favor, Mr. Block?
Aye.
Mr. Alpert,
Aye.
Ms. McKnight,
Aye.
Mr. Owens,
Aye.
and I'm also an aye. Okay, thank you for that. It only took a minute or two. Okay, now we were introducing our next matter.
Yes, Mr. Chairman, I move that we waive the reading of the notice. For the
Second.
division of subdivision.
Which notice, by the way?
Both notices for the division subdivision plan for Chestnut Street for the Heather Lane and for the Heather Lane extension.
Okay, we have a motion and a second. Any discussion? All in favor, Mr. Alpert,
Aye.
Ms. McKnight,
Aye.
Mr. Owens,
Aye.
and Mr. Block.
Aye.
And I'm also an aye. Okay. Those notices having been waived, I believe, is it Mr. Smart who's going to give our presentation, at least to start?
Yes, I will.
Thank you. Please go ahead. And thank you for your patience in waiting to get started more than an hour after you were scheduled.
We should have all had a cup of coffee. Anyway, there are three applications before you. The first is the Heather Lane subdivision, which is a 6-lot subdivision off of Chestnut Street. And then there are two related applications which have to do with a 5-lot residential compound. That is the Heather Lane extension subdivision application and the residential compound special permit. And we would like to have all these applications considered together. With me are Bill Pierzak, one of the principal owners of the property, and David Kelly and Brandon Lee of Kelly Engineering, who might want to put their faces on the screen, but I guess it's up to them. All right, so I'm going to provide some overview, and then David will present the plans in detail. Notice of this proceeding has been given by publication in the Needham Times and certified letters to 23 abutters and 6 abutting planning agencies from the 6 abutting municipalities. The plans that are in front of you represent actually several years of work with multiple meetings with and input from the planning board staff, town engineer, the fire chief, and the building commissioner. I'd ask that our slide number 1 be put on the screen. Brandon, can you do that? Okay. What this shows is the area in question that we're talking about subdividing. It's actually just under 27 acres of land, and it's bounded by Chestnut Street by some abutters, and a good portion of it is bounded by the Charles River. The area is zoned rural residence conservation. Lots in this district, generally speaking, have to have 150 feet of frontage and 1 acre of land. As you can see, it's a little hard to see on this smaller screen, but there are 5 existing residences already on this property. The subdivision area is owned by Bill Pierzak individually, also by Mr. Pierzak as trustee of 768B Chestnut Street Realty Trust, Kobe Kemple, who's the manager of 766 Chestnut LLC, and Evelyn Malumian. Now, Mr. Pierzak has an agreement to purchase the Malumian property. The 5 houses were built many years ago. According to the building department and assessor's records, 764 Chestnut Street, that's the Malumian house, was built in 1942. Mr. Kemple's house at 766 was built in 1930, and the houses at 768, 768A, and 768B, Pierzak properties, were built in increments beginning in 1920. Slide number 2, please. Brandon? Oh, he's already done. He's faster than I thought. We're proposing a 6-lot subdivision with access via a new private subdivision road called Heather Lane. That's in the aqua color with a cul-de-sac. And you can see the largest lot at the end of the cul-de-sac is lot number 4. That lot is about 13.26 acres. And that's actually the subject of the residential compound application. And what's proposed is 5 lots, residential compound lots there. So the total number of lots, if you grant the relief we're requesting, will be 10 house lots. Right now, there are 5 residences. We'll go to 10. Slide number 3, please. Okay, this shows in a little bit more detail the residential compound area. And you can see in a slightly different blue with a almost purple border, the Heather Lane extension, which is basically a private driveway ending with a hammerhead ending so that fire trucks can turn around. So all the residential compound lots will have frontage on Heather Lane extension. So to sort of sum up the big picture here, on about 27 acres of land, we are proposing ultimately 10 house lots. That's about 2.69 acres per lot. The proposals in front of you will have several benefits. First of all, a wider and consistently paved private way with improved access to the dwellings by emergency vehicles, upgraded electrical and water service, improved drainage consistent with current standards, sewer connections for the houses rather than septic systems, and safer access and egress from Chestnut Street. Could I go back to I'm already on slide number 2, great. Okay, so I want to talk a little more specifically about the Heather Lane subdivision. So that would be slide number 2. The owners of the several properties I described previously have joined in the application. Mr. Kempel, Mr. Pierzak, and we have a letter of authorization from Ms. Malumian. Some of the existing buildings on the property will remain and some are going to be demolished as shown on the subdivision plan, and David Kelly will explain that in more detail. Each of the 6 lots has more than the required 150 feet of frontage on Heather Lane, which is going to be a 40-foot wide private subdivision road. Each lot is going to meet all the dimensional requirements under the zoning bylaw, and most of the requirements in Needham's subdivision rules and regulations will be met. Can we have our slide number 6, please? Okay. This is a list of the various sections of the subdivision rules and regulations, and indicate the ones which we comply with and the ones which we are asking for waivers on. We're requesting 7 waivers. These include a 40-foot right-of-way width rather than 50, 20 feet of pavement rather than 25, and a waiver of sidewalks. David Kelly will go over the remaining waiver requests in more detail. And the waivers that we're requesting appear in many of the board's subdivision decisions. The owners of the subdivision lots will be required to join the Heather Lane Association, which will become the owner of Heather Lane, and will be obligated to maintain and repair as necessary the road, utilities, and drainage system shown on the plans. Although Heather Lane will be and remain a private way, the town of Needham will have the right to enter upon it for all appropriate purposes for which public ways are used in the town. And the restrictions and covenants in the Declaration of Restrictive Covenants will run with the land and be enforceable by the town. Drainage issues will be addressed by Kelly Engineering. We've submitted drafts of a declaration of trust for the Homeowners Association, Declaration of Restrictive Covenants, the Subdivision Covenant, and utility and drainage easements. These are modeled on the Riverbend and Burr Drive subdivision documents previously approved by the planning board. Let me summarize briefly what's in those documents. The Homeowners Association, Bill Piersack will be the initial trustee. After lot sales, each lot owner shall be able to appoint a trustee. And the trustees will adopt rules and regulations on use, maintenance and repair of the road, utilities and drainage, and they can assess common charges. The declaration of restrictive covenants, that prohibits parking in the Subdivision Road. There'll be a declaration that the road and utilities will remain private, and there'll be a requirement that each lot owner contribute equally to the cost of maintenance and repair. The subdivision covenant gives the owners give a covenant to the town that lots are not to be built upon until the road and utilities are constructed as required by the planning board's decision. We have a drainage easement. This is a grant of a drainage easement from the 768B Chestnut Street Realty Trust, which owns lots 5 and 6 on the proposed subdivision, to the town of Needham, the Heather Lane Association, the Homeowners Association Trust, and the Heather Lane Extension Homeowners Association Trust. We also have a proposed utility easement, and this is a grant of utility easement from the owners of the whole subdivision property to the town of Needham and to the two homeowners associations. So we're requesting that the Heather Lane subdivision be approved. Turning briefly to the Heather Lane Extension Subdivision Residential Compound. This lot 4 of the Heather Lane subdivision contains 13.26 acres, and it's owned currently by Mr. Piersack. Could I have slide number 3, please? We're proposing to divide lot 4 into 5 residential compound lots with access via a private drive running off the Heather Lane cul-de-sac called the Heather Lane Extension. And we have filed both a subdivision application and a residential compound special permit application as required. The zoning bylaw encourages the creation of residential compounds to provide limited development up to 5 lots within large tracts of land over 10 acres, with at least 2 acres per dwelling unit. And the idea is to minimize town responsibilities and preserve to the extent possible the rural character of the land. So the land to be subdivided into residential compound lots has several buildings on it. Now, some of these buildings are going to remain and some are going to be demolished. Again, Mr. Kelly will explain that. All of the requirements, the zoning requirements for a residential compound will be met. Those requirements are, could I have slide 5, please? The number of dwellings, not more than 5. We're proposing 5. Minimum density 10 acres. We have 13.26 acres. Each lot will have at least 2 acres. We have tract frontage on a way, namely the Heather Lane Subdivision Road. You're supposed to have 150 feet of frontage. We have 232. You have to maintain a minimum distance of 30 feet between structures and ways and 20 feet from any tract boundary line. And these requirements are met with the proposed lots. Each building lot is supposed to have access via a private street or driveway. Heather Lane Extension is such a private street or driveway. The application does require some waivers from the subdivision rules and regulations. And this is in keeping with the purposes of the residential compound section of the bylaw. Could I have slide number 7, please? The waivers requested include a reduction in pavement width from 24 feet down to 20 feet, and a reduction in the right-of-way width from 50 feet down to 20 feet. The reduction in right-of-way width is consistent with board practice. In the board's decision on the Riverview Estates subdivision and residential compound, that's Mwr Road off South Street, the board approved a 20-foot right-of-way, recognizing the special character of residential compounds. The owners of the residential compound lots will be required to participate in the maintenance and repair of Heather Lane extension, but also in the maintenance and repair of Heather Lane, because they're going to be using it. And although Heather Lane extension will be and remain a private way, the town will have the right to enter on it for all appropriate purposes. The residential compound lot owners will have their own homeowners association. So it's very similar documents: a declaration of trust, a declaration of restrictive covenants, subdivision covenant, and drainage and utility easements. Very similar to the documents for the Heather Lane subdivision. So the owners of the Heather Lane extension, the residential compound lots, will have the responsibility not only for the maintenance of the extension, but they're also going to contribute to the maintenance of Heather Lane itself. So I want to request that the application for special permit for residential compound and subdivision be approved. Do you want me to address the comments from the town boards now, or to save that for later?
Well, let me, would that be the end of your presentation, Bob, right now?
No, well, David Kelly.
We're going to have David present now, right?
Yes, yes. Well, I want to give, the only other thing I wanted to say is, before addressing the comments from the other boards, is that we do have, we did receive letters of support were submitted electronically to the board from three of the immediately abutting property owners, the Jays, the Grossmans, and the Hasiotises. And I understand from my client, Bill Pierzak, that he spoke with another abutter, Peter Palladino, and who indicated that he was supportive. I mean, we don't have a letter, anything in writing from him, so I don't want to, say something out of turn here. But that's what my client told me.
I'm going to propose that you go ahead and address the comments from the town boards. It may be a little premature, but it's probably not a bad idea to get it all out there right now. Go ahead.
Yeah, it should be fairly brief. The DPW, the engineering division, indicated that the proposed plans showed the agreed changes that we've been discussing over many months. They're asking that as part of the NPDES requirements, we comply with the public outreach and education requirement, and that we submit a letter to the DPW identifying measures that we will take. We'll do that. They have reviewed the drainage calculations, and they are suggesting dry wells for each house. I think it's probably best if David Kelly speak to that rather than me. The fire department, police department seem to be perfectly happy with the application from their comments. The Board of Health wants us to let the owners and builders of any structures know that if there's going to be any demolition, they have to fill out the notification of demolition form, give it to the Board of Health before the demolition can go forward. And they want drainage sureties of paid of $3,500 per lot. We'll do that. And they've listed 5 off-street drainage requirements. I won't go through all those in detail, but we don't have a problem with any of those. With regard to conservation, they suggested that we file an abbreviated notice of resource area delineation. We've already had some communication with the commission, and we'll certainly work with them on that. They've also suggested that a conservation restriction might be warranted in this case. As pointed out in the commission's letter, the site has several overlapping resource areas due to its proximity to the Charles River. Protection of those resources is already provided by the Wetlands Act, the Town Wetlands Bylaw, the Rivers Act, and the Floodplain Zoning Bylaw. So we don't think an additional conservation restriction on top of that is needed. I think that's it for my part of the presentation. I don't know if Bill Pierzak has any comments, or if he wants to just go directly to David Kelly.
Hi, my name is Bill Pierzak from 768 Chestnut Street. I don't have any comments at this time, but I'm happy to answer any questions that may arise as a result of Bob and David's presentation. And with that, I'll turn it over to David.
All right, I'm going to take the liberty, if you don't mind, of calling a 5-minute recess. All right. It's just after 9 o'clock. Why don't we say at 9:06 we'll reconvene, okay?
Thank you, Mr. Chairman. I had to plug in my computer. It was just about to fail me, but I appreciate the recess too.
Okay, thank you. In 5 minutes, we'll be back.
I have recess for 5 minutes. Hello? Huh. Yeah. I've never had a recess in a meeting, but now we have a recess, which is great.
Hey, Suze, can you come to my office?
Just waiting for Paul. And then we'll begin. There's Paul. Okay. Okay. I see all members of the board, Mr. Smart, Mr. Piersiak, Alex and Clay are on the line, as is Brandon. And I think we're all here. So I'm going to turn the floor over to Mr. Kelly.
Good evening, Mr. Chairman, members of the board. David Kelly with Kelly Engineering Group. Just wanted to respond quickly to Attorney Smart earlier. It's not that I don't want you to see me. We remote desktop into the office, and if I was to turn the camera on, you wouldn't see anything. So that's the reasoning, but we'll maybe change that sometime in the future. So Attorney Smart, I think, did a really nice overview of the project. What I'd like to do is fill in some of the gaps, provide some of the thought process in how we came about the subdivision that you're looking at, the engineering aspects of it, and to explain where we are in the process. So thanks, Brandon. Brandon's going to run, rather than jumping around, Brandon will run the screen presentation. So as was pointed out, the property is located in the rural residential zoning district. That's a 1 acre zoning district. It's accessed from Chestnut Street, as you can see on this plan. And one of the important items on the boundary of this property is the Charles River, which is located on the bottom of this plan on the south, the east, and the west. As Bob pointed out, there are 4 lots that would comprise, 4 existing lots that would comprise this subdivision. Mr. Temple's lot is 6.63 acres. The 764 Chestnut, Miss Malumian's property is 1.21, and Mr. Piersiak, the applicant, is 19.06, all adding up to 26.9 acres. The right-of-way that it currently exists on the property and provides access to all of these properties along that way is approximately 15 feet wide. For those of you who know it or have traveled on it, it's a beautiful lane that extends from Chestnut Street to Mr. Piersiak's property, which consists of a number of different structures. And Brandon, maybe you could just show photos 12 and 13 really quickly, just to remind the board what it looks like. Thank you. So this is a photo of a reasonably new wall built on 766 Chestnut Street. But you can see this is looking up towards the property, into the property from essentially from Chestnut Street. And you can see the width of the pavement. And what's most obvious, I think you'll see here, is that the road weaves and meanders to follow the topography, and the way, I should say, follows the topography and maximizes the retention of trees. So it's a really nice entry feel in a rural setting. And you'll see, as I explained the proposed design, that we're trying to repeat that. There's one more photo that shows the entry. Brandon, if you could do that, the number 13. Yeah, not a great photo, but there's a pillar on the left side, a stone pillar. That's the entry, the current entry to the driveway. And we're looking into the property. So the same situation, it's essentially, we've got a paved width as it travels through the site of 10 to 14 feet. And again, you can see that it really just works into the topography that exists on the site. So if we go to slide 2 quickly, and a lot of these slides you've seen, and really I will try not to be repetitive because Bob did a very nice job in presenting it. But the new Subdivision Road, which extends off of Chestnut Street and extends towards Mr. Piersiak's current property, generally follows the existing layout of the driveway, the right-of-way that's in there today. However, it's just going to be widened and improved to current standards to provide easier and better access for both occupants of the property and for fire and other emergency vehicles. The entry on Chestnut Street, the entry curves will be flattened a little bit. That will provide better sight distance up and down Chestnut Street. Currently, there's adequate sight distance in the order of approximately, 750 feet to the north and about 550 feet to the south towards Dover and the bridge. So there's plenty of sight distance. What we're just doing is widening the throat of that driveway and doing some clearing along the edges that provides more enhanced frontage. The subdivision design is the result of a lot of collaboration over, as Bob pointed out, a number of years with both town departments, in particular planning and DPW and fire. The result you'll see on this plan is a 6-lot subdivision, one of which is the rural, was a residential compound, which Bob explained, and I'll explain a little bit further in a moment. The road length is 980 feet, so no waiver would be required under the current subdivision regulations. And then the proposed roadway is similar to most recent subdivision roadways that the board has seen and approved and supported in the RRC, the Rural Residential Conservation District. Brandon, if you could just show slide 4 just quickly, please. This presents a cross section. This is taken from the plans, but if you were to look at this, you'll see we have 20 feet from lane to lane, curb to curb. Then we have a bituminous Cape Cod style berm, typical of what you'll see in other similar developments. And the total right-of-way width is 40 feet. And you'll see on this plan that there's lighting shown and the various other components that you'd see on a typical street cross-section. Some of the other applicable portions of the subdivision or components of the subdivision, we have a cul-de-sac with a radius of 60 feet and a cul-de-sac with a pavement width of 25 feet, all as agreed upon and discussed with the fire department. And as you'll see, and as presented by Bob earlier, there's a letter in support from the fire department. We're proposing a landscaping plan on the road. As I noted, the goal of the development is to follow that driveway as much as possible, match the grades as much as possible, but to also maximize the retention of trees along that roadway. In order to meet the requirements of the subdivision, as hopefully waived to the width that we're asking for, there will be some removal of trees, but we've tried to minimize that removal for all the reasons that are obvious and that add to the character of this development and the existing property. To mitigate that removal and to essentially infill areas, we're proposing approximately 17 street trees along that new right-of-way. There really isn't room to put any more because we're maintaining much of the trees that you saw in the photos that you saw earlier. With regards to lighting on the site, we have proposed a lighting fixture that's very similar to a fixture you've seen in the past. This is a lighting fixture that you'll see on Riverbend Lane, for instance. It's a downward-facing traditional lighting with cutoff fixtures, lantern style, that will provide sufficient lighting in an attractive way without spilling off the site or causing any interference with other users. So the goal of this development really is to try to maintain that rural character and not to create excessive light for either on-site or off-site use. If we could just look at the waiver list for a moment, that's slide 10. I'd just like to take you down through it quickly. I know Bob spoke to the major waivers. I will hit those again, and then I'll explain quickly the other waivers. There really are technical waivers. They've been supported by DPW, and most of these waivers you've routinely granted in the past for similar developments in rural areas. The right-of-way width Bob spoke about, 50 feet is required. As you saw a moment ago, we're proposing 40 feet, which is sufficient for provision of the width of roadway that we're proposing. The pavement width, routinely waived by the board from 24 feet to 20 feet. We're requesting a waiver again in this case. The street slope at the intersection, what that means is where the roadway meets Chestnut Street, the subdivision regulations require that to be 1% for 50 feet. We're proposing 2.6%. This is a waiver we discussed with the DPW. The reason for that waiver is that there are existing driveways. Mr. J, an existing homeowner along that way, his driveway is located at a certain elevation, so we're matching that elevation. 2.6% slope is actually quite a flat slope, and as noted, we're not proposing a very dense development, only one unit essentially per 2.6 or so acres. The radii at the intersection, just because of the location along one side, we can't quite meet that radius, but we're flattening out on the side that we control. 20 feet is required. What's there is sufficient, and the improvements we're proposing will enhance that. Again, that's supported by DPW and discussed with them at length. As is typical, curbing would be granted or bituminous. We're proposing a Cape Cod berm. It's a slightly different type, but better bituminous berm. It would require a waiver. This is one that the board has routinely seen. It enhances the rural character. It's a Cape Cod style berm that sort of rolls slowly upwards. With regards to sidewalks, we're asking for a waiver. There are no sidewalks on Chestnut Street in this location. There are none on South Street. We feel that with the low density on this site that there really is not a need, that pedestrians could comfortably walk along this street, which is 20 feet wide. There's finally in the standard cross section, that really is just a discussion of the cross section itself, which we would be waiving due to the right-of-way width and the pavement width. That's a list of the waivers that we would request respectfully from the board. Bob mentioned the stormwater system on the property. What we're proposing to do is to fully comply with the town's new regulations and the DEP regulations, which are slightly less restrictive than the town's regulations. What it consists of are deep sump catch basins with a stormwater management pond that will have recharge and water quality components. We worked in detail with the DPW in the design of that, and their letter, as you can see, an email from Tony Delgado today supports that design. Bob mentioned, and it's correct, that all utilities are either available or can be extended in from Chestnut Street. Those consist of all the standard utilities, including an upgraded water main that will have hydrants and provide fire protection for the existing and new homes. Finally, with regards to utilities, we'll be proposing a sewer system on the site. There is no sewer connection for the properties that exist there today. And so we're proposing to connect the new subdivision to the existing sewer main that actually traverses the property today. It was an old MDC sewer easement that's currently owned and maintained by the town. So that's a general overview of the subdivision itself. And I can certainly get into more details, but I just wanted to reinforce that the goal of our plan and the reason for many of these waivers is to match what's out there, match that rural meandering feel as much as possible. That helps us to match grades on the existing ground as much as possible, and minimize tree removal. That's the overarching design component of the subdivision. If I could just speak to Heather Lane Extension for a moment, which is the residential compound subdivision. Thank you, Brandon. As Bob noted, we're proposing 5 new parcels. As a part of that, there are a number of properties on the existing site today. Only 2 will remain. They're highlighted in the orange color on the plan. Thank you. 1 there, and 1 which is an existing barn that presumably will be converted back into a residence. There'll be 3 new homes built, and the remaining buildings would be demolished. One thing that Bob noted, and it's clear on this plan, is that the river and its associated riverfront area also contains wetlands and floodplain, but there's one other restriction, if you like, on parallel to the river, and that's one that you might remember from Riverbend. It's the same restriction. There's a natural heritage endangered species line that runs approximately 300 feet or so, plus or minus parallel to the Charles River for protection of a rare dragonfly. You may remember that from Riverbend. That same restrictions apply here, further reinforcing Bob's point that the areas that are adjacent to the river are already protected by virtue of state and other permitting. The residential compound lots range from 1 to 7 acres. The right-of-way, just like the Heather Lane itself and the new roadway, really tries to follow the existing topography and the existing driveways as much as possible, with the goal again to limit disturbance and create that rural feel while still providing additional safety and comfort of access for pedestrians and other vehicles. The right-of-way length, for your information on this plan, is 329 feet. It has a 20-foot right-of-way width and a 20-foot paved width. So essentially the right-of-way is the same width as the pavement. With regards to waivers, Bob explained the reason why this property, explained quite well with that slide, why this property would fully comply with the requirements and the underlying dimensional requirements of the residential compound. But if I could just quickly go down through the waivers in slide 7 for just a moment. Thank you, Brandon. So one of the important things, and it's noted on the plan, is that even though this is not technically, it is a subdivision, but it's a subdivision under residential compound. It says that under 4.2.12E1 that the residential compound shall meet to the maximum extent practicable the subdivision standards. And so presumably what that meant is we need to provide a safe, effective driveway and way to provide proper access to these new lots, residential compound lots. And so what we've done is listed here what those subdivision requirements could be, and many of them I think are pretty obvious, are not really applicable, even though we've listed them here because section 4.2.12E1 requires us to look at them. With regards to right-of-way with the subdivision, as we talked earlier, would require 50 feet. We're proposing 20 feet, as I noted a moment ago. Pavement with 24 feet, again, would be required for these five homes. 20 feet is what is proposed. The street slope, again, 0.7% to 8% is what your subdivision regulations require. We're 9% here. Again, the reason for that is quite simply to limit the grading on the site and to match the ground as much as possible. And for your information, that's what's there today. And so if you were to drive on it, those are the slopes you drive on, and they're quite comfortable. It seems high, but it's actually really not, especially for the density we're talking about. So again, the same requirement on the street slope we talked about a moment ago. This time it would be the intersection with the Heather Lane cul-de-sac, and the requirement would be, if you were to follow the regulations, 1% for 50 feet. We have 2% proposed, which is a typical slope. It allows us to match the grade more closely to what's there, and it's supported by the DPW. Radii at the intersection, the same applies here. Really, this is a driveway, and so what we're trying to do is make it look more like a driveway, not look like a subdivision roadway, while still providing ease for access for vehicles and emergency vehicles. The minimum center line radius will be 100 feet. We're showing 50 feet, again, to try to best match and maintain the existing structures as much as possible. Curbing, we're showing no curbing here, which would be very typical and consistent of a driveway situation. The drainage sheets off in each direction and essentially infiltrates into the ground, which is a more informal drainage method, different than what's proposed in Heather Lane. A simple one with regards to granite bounds, those would normally be required in a subdivision. We see no reason why those would be necessary here. These are all just individual lots sitting, individual parcels, if you like, sitting on the one lot. Again, the sidewalk waiver, 3.3.16. And then the standard cross section, the same waiver we discussed a moment ago. So summarizing that aspect of it, the goal of these waivers and the goal of our development is really to minimize impact here and to try to maintain that rural feel. I've said that a number of times, but clearly that's the theory and design behind this design. Storm drainage on these sites will be handled individually. The DPW did have one comment that remained, and that was that the on-site homes will need to comply with the current regulations for stormwater, and those regulations require that the roofs be recharged into the ground. We've done that for many, many years with projects in Needham, and this really just puts in effective writing what we've been doing for many years, and we would propose to do here as well. But it's now in writing in your stormwater management regulations, and we would comply with it. And that would serve to send more water back into the ground. Mr. Chairman, that concludes. So Brandon will show you that dry well that would be shown on the plan in the corner of a home. Mr. Chairman, that concludes my presentation. I can go back and cover any pieces of it. I hope I wasn't repetitive. I tried not to be, and I know it's late, but thank you for your patience.
Thank you, David. Okay. Going to open up to comments from the board. Jean, would you like to start?
Well, thank you. Yes. Excuse me, I know I made some notes, but I made so many I have to turn the page. Okay. On the Heather Lane extension, if it's all right to go back and forth from Heather Lane to have a Heather Lane extension in my questions.
Sure.
A big issue I have is that the pavement will be 20 feet wide. That seems fine. But the right-of-way width will only be 20 feet wide also. No, I think 20 feet is sufficient for passage of one vehicle to pass another. And I know that this is a small subdivision, but you have to concern yourself about delivery vehicles and emergency vehicles and so forth. But if you don't have any right-of-way outside the paved area, how is snow to be disposed of so that you maintain that 20 feet? You showed, there was a photo shown of a new stone wall. I think it was photo number 12. And that's exactly the kind of thing I'm concerned about. If the right-of-way is 20 feet wide, the abutting owner could put a stone wall right up to the edge of the right-of-way, and there goes any possibility of plowing snow over to that side. So I'd be more inclined to a 25-foot right-of-way with a 20-foot paved area. And I don't know, I also have another question about the right-of-ways. So if Mr. Kelly wants to answer both of them, I'll ask the other one. Regarding drainage, the document seemed to focus on the lots and how each lot will deal with the drainage from that lot. And that's great. That's the town's new rules. I'm all for it. But it's very difficult to review plans by looking at them on a small computer screen. There must be drainage structures in the roadway and in the Heather Lane Extension driveway to deal with the drainage of the ways themselves. And I just want to make sure that there is and that that's adequate. I guess my other major comment is the phrase preserve rural character was referred to several times. And that's the reason for narrower roadways and other waivers. And I think that if we share that goal, preserve rural character, we would want to take seriously the Conservation Commission's wish for a conservation restriction, because I think it's not that maybe I'm wrong, and it could be clarified. I don't think it's the Conservation Commission wanting to pile restriction upon restriction unnecessarily. I think it's a matter of public access along the river. And that what the Conservation Commission is really talking about is enabling people to walk along the river. And the plans show the MWRA sewer easement, which I understand from Mr. Kelly's comment, is now owned and operated by the town. It's kind of surprising. But I do know that some of these MWRA sewer easements are only backup easements anyway. And it sounds like you're going to be able to use them to discharge the sewage. But what I'm saying, thinking is, just because you have an MWRA sewer easement doesn't mean people necessarily have the right to walk upon it. That's a separate issue. So I really think we should take seriously the idea of enabling people to walk along this beautiful area as a way of enabling the enjoyment of this rural character in this rural part of our town. Let's see. Perhaps other comments I might have had as I went along will come to me, and I might have follow-up questions. But those are my three major questions now. Thank you.
Thank you. I'm going to turn to Mr. Kelly and see if you would like to respond to those three issues in particular.
Mr. Chairman, excuse me, I'd be pleased to do it. Yes, Ms. McKnight, there's an extensive drainage system in the street. This is obviously just a cartoon plan, but the detailed plans that the town has reviewed and are in your packages as well will show a series of catch basins on the streets that are interconnected with storm drains, and those tie into what would be a traditional stormwater management pond that includes recharge components and water quality components before it ultimately discharges off the site after mitigating the storm runoff from the site. So it's all traditional on the main property. On the residential compound, it's more of a rural field. So essentially we have limited amounts of impervious area. and those impervious areas just slope off into a country style drainage system. But Heather Lane itself, the main subdivision roadway, has a traditional stormwater system, again approved by the DPW. Maybe I was confused the board, but the remaining comment was that they had noted that they reviewed and approved the stormwater management system in an email to the board today, but they noted that the lots themselves, which are not reviewed here, would need to conform to the current regulations, which require subsurface systems for recharge. With regards to the Mwr easement, there are a number of Mwr easements on the property. There's one that runs along the Charles River. That's an active easement and remains. There was, if you like, an old easement that ran across through, essentially through where that existing lot is called out on this plan that you're looking at on the left side, and went northwards. That was an old Mwr easement that has since been abandoned, and the town took control of a section of it to provide sewage to some of the properties nearby. We will connect to that line. So we won't be connecting to the Mwr easement that you're speaking of. We'll be connecting to the town's line that runs north-south on this plan, not the Mwra sewer line that essentially runs along the Charles River. And that's an Mwra easement, excuse me. And then with regards to conservation restriction, I'm sure Mr. Piersiak and Mr. Smart would comment on that. From our standpoint, as I noted earlier, there are many other restrictions on this site that prevent work from happening along the river relative to the protection of those resources, and not necessarily what kind of active uses might happen in there. Thank you.
May I ask a follow-up question on the very points that we just responded to, Mr. Chairman?
Please.
Yeah. With regard to the fact that you reminded me that there's no berms on the side of the paved area of the way in the extension, doesn't that create difficulty with channeling the drainage from the pavement? And then also, Mr. Kelly, you didn't answer my concern about snow storage to the side of that way.
Mr. Kelly.
Yeah, okay. Yeah, thank you. So those are good questions. And with regards to the question of the drainage, it won't channel. Essentially what we have is an even cross slope across. It's a reasonably flat driveway. So we're not concerned with that. And it's not long and it's reasonably narrow. The total is only, if you did the math, 300 times 26,000 square feet, which is really a sort of, an average roof on some homes in Needham. So it's not a substantial amount of impervious area. So what we're trying to do is maintain that more rural character, to let people know as they arrive here into that cul-de-sac that they're leaving that cul-de-sac and going into a private compound that would be typical of a driveway you might see in any other another home or homes in Needham. With regards to the snow storage, it's a fair question. The documents that Bob prepared have common requirements for maintenance of the roadways and other systems. We probably should consider it. I think it's a good question, and we may want to consider widening the right-of-way, as you've suggested, to allow for some at least windrowing of the snow like would normally happen on any property. But all the owners will own this right-of-way and will ultimately be responsible for its maintenance, like any other common driveway that you might see in Needham. So it's probably not a real issue, but it does make sense, we think, and we will certainly look at that, widening that right-of-way to benefit each of these properties. Thank you.
All right, thank you. Anything further, Jane?
Not right now, thank you.
Okay, thanks. Mr. Block.
Thank you, Mr. Chair. I admit that I need a little more time to go through in a little more detail some of the declaration of trust and some of the other documents. I have had a chance to have a cursory view. One question that comes up is whether the ownership group would consider, with respect to the declaration of trust for both the Heather Lane subdivision and the Heather Lane extension, to say that that the owners shall be jointly and severally liable. That's one question that I have, which I guess we don't need to answer immediately. I had an opportunity to speak with Attorney Smart earlier today, who answered a number of questions, and yet I still do have a few engineering questions as well. The first is with regard to the Heather Lane subdivision, the sloping of 2.6 rather than 1%. That's a slope of greater than 100% of the existing slope. So my question was, does that delta, what effect does that delta have on any kind of drainage or water on the property? That was one question. There is, with respect to the curbing, I understand that you're looking for some relief on the curbing with Cape Cod berms, and that it's proposed as a result of transition issues. I'm curious what those transition issues are. I understand there's relief to avoid the installation of a sidewalk, which I understand has the board in certain cases has previously granted. And that's something I'm sure that the board itself will want to consider again here. I'm looking through with respect to Heather Lane extension. There is a slope of 9% rather than 8%, which I understand the engineer had mentioned, and I think you mentioned that that's the current condition of that section. I don't know if I'm right on that. I had an opportunity to drive the lot, and I was just curious, what effect the change would have for all of the owners or any of the individual owners as a result of a change in slope from 8% to 9%. But, if it's an existing condition, or with respect to Heather Lane, if the existing slope is 2.6 and there has been no adverse impact, then I'm satisfied with that. But I was curious about those. And then my last comment, it's actually a question, is how is the creation of the Heather, I have 2 points actually. How is the creation of the Heather Lane extension not in violation of 4.2.12 C of the zoning bylaw? And my last question may have escaped me. Perhaps it may return to me, but Mr. Chair, those are my comments and questions at this hour.
Mr. Kelly. Do you have the questions?
Yes, Mr. Chairman. Thank you very much, and I can probably quickly answer them, and maybe a little more definitively than we spoke about earlier. So the question regarding the entry to Heather Lane from Chestnut Street. So as we noted, we're asking the board to consider a waiver from 1% to 2.6. So that, if we think about that for just 1 second, so the goal of that is to create a flat level area so that a vehicle can easily slow down and easily make the turns, etc. But just to put that in perspective, 2.6% is a cross slope on a roadway, which most people would consider to be flat. If you're driving down the highway, most people would consider the left to right slope on the highway that you're driving essentially flat. That's actually at 2%. So we're really talking about quite a flat slope regardless. And this photo doesn't really do justice to it, but it does show what we're talking about. It depends on the angle of the photo, obviously. But it's a slight slope. It's not very extensive. And the issue with it is that driveway that you see on the right side, which is Mr. J's driveway, we wouldn't be able to meet that driveway grade if we were to flatten the slope over that length. That grade would have to go down by about a foot, and we would have difficulty entering Mr. J's driveway. We wouldn't be able to do it without his permission. It doesn't really provide any benefit. It's a unique requirement to Needham. The goal is generally to create a level area near an intersection, so that people know they're sort of ending the driveway or the roadway and getting to a major roadway. We're not concerned about it. We've discussed it with DPW at length. They're not concerned about it either. And it's not as steep. Yes, it's 260% of the or 160% extra of the number, but that's not such a small number to start with. That really doesn't provide any real guidance. To give you some more guidance on slopes, a slope in a parking lot is generally no steeper than 5%, and that's a very easy slope to walk on. That would be a walkway that you might see the maximum slope on a walkway is 5%. A cross slope on a walkway is 2%. So we're really talking about very flat slopes here, and we're not concerned as engineers that those will create any negative impact. With regards to drainage, we have a drainage system proposed in the street that is better than what you're looking at in this photo. In fact, we'll be picking up all the drainage. We'll be creating berms on each side and trapping all that water and taking it back to that pond as we talked about earlier. So that would be an enhancement of what you see in that photo. With regards to the curbing, so what the bylaw allows for granite curbing or bituminous curbing. Bituminous curbing we just don't use anymore. It's old-fashioned vertical bituminous curb that just gets killed by the plows. It doesn't look attractive. It's that old bituminous curbing that you see in old parking lots that is usually pushed into the landscaped areas because it just gets knocked right off of the pavement. What we're proposing is if you were to drive down Riverbend Lane, for instance, that's the type of curbing we're talking about. It's a very low profile. It really just sort of turns up the edges of the pavement in a sort of attractive way without really looking like you're in a parking lot or on a main road. So it's been typically used. So again, it's something the board has routinely waived, and it's something that you've seen throughout the town, and it's quite attractive, and it's more natural looking than a vertical curbing. With regards to the last question, which was Heather Lane extension, the slope of 9%, as you said, a member block, you did look at it. It's a comfortable slope to drive on, and it's just in a very limited area. And the issues with it is that there's an existing home we're trying to maintain, and as you change the slope there, you start to interfere with the existing access to that building and also to vegetation. You'd have to lower the grade in that turnaround area. Again, we don't feel that's an impact. Clearly, if the board does, we would have to address that, but that would be the impact if we were to address it. We would have to lower the grade, there'd be vegetation removal, and we might have to reconfigure certain aspects of that existing home to make it work. But thank you. Those are really good questions. Hopefully I answered them sufficiently for you.
Mr. Chairman?
Yes.
Bob Smart here.
Just to follow up on response to Mr. Block's questions, 2 points. He mentioned the possibility of changing the language in some of the homeowner documents to call for joint and several liability on the part of the owners. I haven't seen that in prior similar documents, but I'll discuss that with my client, and we'll certainly get back to the board on that question. The second is, I think Mr. Block said he was wondering about compliance with a section of the residential compound bylaw, which, and Mr. Block, I think you mentioned subsection C, is that correct?
Yes.
Okay. What that says is that no residential compound for which a special permit has been issued under this section may be subdivided or further developed, and a notation to this effect shall be shown on the plan. Well, I don't think this section applies. I think it would apply if the residential compound proposed here had actually already been built, and the owners then wanted to come back and further subdivide or create additional lots. So they wouldn't be able to do that.
Mr. Block?
I appreciate that. So help me understand if you can. Under the proposal for the Heather Lane subdivision,
right?
Are we not taking that lot and further subdividing it, which in itself would then be in contravention?
Well, no, because that's a subdivision. What this subsection C talks about is a residential compound. Lot 4 of the Heather Lane subdivision is not already a residential compound. We're proposing to create one. We're proposing to get a special permit to create that residential compound.
Right.
So again, assuming that's approved and it's ultimately built, we would be prohibited from further dividing that.
I understand that distinction. I have to study that a little more, and I appreciate your explanation. Thank you.
Okay, sure.
Thank you. Mr. Owens?
So I do have a couple of comments. I start with a very positive reaction to the overall proposal. This is, a little corner of the town that is somewhat remote, and I think that there's some very creative thinking going into how to develop this little corner of the town. I'm particularly fascinated by the idea of the residential compound because it's something that was put into the zoning bylaw but has not been used much. And to me, it's very interesting to see it used in this situation. I do have a couple of comments though on the general subject of waivers. And what I have to say won't come as any surprise to my colleagues because they've heard me say this before. I start with a bias that when the zoning bylaw was drafted, that the people on the planning board who made the proposals and the people in town meeting who approved the zoning bylaw had a vision of what they wanted it to look like. And so I'm always curious about a request for waivers. Any developer always has the option of, you could just develop it and comply with the zoning bylaw and, nobody would give you any pushback at all. So I'm always interested why people ask for waivers. And in this case, what I hear is there's a desire to preserve the rural character. We want to minimize the impact. We want to minimize tree removal. We want to follow the current topography. All of that is interesting and it's persuasive, you know, and it depends obviously on the facts on the ground. The argument that I do not ever find persuasive, and you know, I may be alone in this, is that these waivers are consistent with past practice. These waivers were routinely granted in the past. The reason I don't find that persuasive is because the circumstances of each piece of property is different, and maybe there was a good reason to grant the waiver in the past. So just that that prior planning boards, because it's not these 5 people, just that previous planning boards have granted similar waivers, you know, my reaction to that is sort of, so what? I mean, it doesn't really make a difference to me. I'm still looking for the explanation as to why the waiver makes sense in this particular case. So when it comes to the waivers, I'm probably looking for a little more information than we've got so far. So one of the columns that's missing on both of those lists of waivers is the existing situation. And I'll give you an example. So as we talk about Heather Lane, even though your proposal for Heather Lane doesn't comply with the zoning bylaw, it is clearly an improvement over what is there today. So that's an argument that I, you know, would find persuasive. So I'm interested in the lists where we go through the waivers. We talk about what's required in the bylaw, what you're proposing, but you aren't giving us yet the current conditions. And you've talked about it verbally as part of this discussion, you know, in the item that Adam just brought up. You know, you're saying, okay, 9% is fine because that's the existing topography of that particular piece on the extension. So I'm interested in more sort of explanations, some more commentary on why the waivers are beneficial and why they make sense. And, you know, as I said, if it's an improvement over what's there, to me, that is something to consider. It doesn't necessarily, if you're moving from 50% of what the bylaw calls for to 75% of what the bylaw is calling for, you know, it's still a waiver, but you're certainly moved it in the right direction. I also want to say that I agree with what Gene said about the right-of-way width. I mean, to me, and again, you know, I'm not the real estate lawyer here. I'm not a developer. I'm not an engineer. And so when you talk to me about the width of the roadway and making it 20 feet, I say, okay, that makes sense, but I don't understand why the right-of-way doesn't have to be in compliance, particularly in this situation where you yourselves say that the right-of-way is owned by the association. So it's owned by everybody anyway. So what difference does it make whether the right-of-way is in the road or the right-of-way is in the private part of the land? One thing that I don't necessarily consider persuasive is we want it to look like a driveway. It's not a driveway, but we want it to look like a driveway. So I'll tell you what I hear when I hear those words. What I hear is the property values will be higher if it looks like a driveway than if it looks like a roadway. And I'm not sure that's necessarily persuasive. You can convince me that if if it's 20 feet of pavement and the fire chief is happy with that, then I'll be happy with that. But again, I'm not sure. I'm not sure why you need a narrower right of way. So, you know, my general request is that I would be interested in, for each of the waivers, two things. One is, what is the current condition, and just some additional commentary, some additional narrative as to why this waiver is still a good thing. That's all I have.
Thank you. Mr. Kelly, you want to respond?
You don't have to.
No, Mr. Chairman and Mr. Rose, we're pleased to do that. Those are fair and good comments, and we're pleased to provide that information to you. Thank you.
Thank you.
Very good. Mr. Alpert. Paul, you with us?
Mute.
I'm sorry, I didn't unmute.
Okay.
The hour is late. I have to admit I'm getting tired. I also have to admit that given when we got 244 pages of materials for tonight's meeting, I did not have time to really focus in to the extent that the other board members have on this subdivision. And so I think the comments that the other three board members have made are right on point and excellent. And I need more time to look at the bylaws and read some of the documents that I haven't had a chance to read. And so if I'm going to make more comments, I think they'll be at the next meeting.
Okay, thank you. I had a number of comments to make, but I think everyone stole my thunder. So, but I also, and I mentioned this to Bob Smart when I talked to him earlier today, I really haven't had a chance to delve into the details of the various drafts he gave to us. I'm happy he gave them to us. Don't mistake my meaning, but I haven't had a chance to study them yet. So I don't have much to say about those. But the hour is getting late. It's about 10:10. I'm just trying to think about the best way to proceed on this. Lee, have we received all the comments from town boards and departments that we anticipate receiving?
Yes, we have received those. If you like, I can note those for the record.
Please.
We have an email from Dennis Condon that's dated today's date. We have an email from Tony Delgazzo, the town engineer, that's also dated today's date with his comments. We have a memo from Thomas Ryder, the assistant town engineer, dated 6/15/2020. We have recommendations from the Board of Health dated June 9th, 2020. And we have an email from the police chief, John Schittler, dated also today's date. And then we received, I think, by email, comments from three folks outside of the town, a George Hasitosis, I hope I got his name right, 6/15/2020. A Sarah Grossman, also dated 6/16/2020. And an email from Jake Kevin, dated 6/16/2020.
Thank you, Lee. Let me just ask you one other question, Lee. As you understand the DPW's position, did they have any issue with the right-of-way width matching the pavement width?
They didn't call that out as an issue in the comments that they gave us. It doesn't mean that it's not something that should be that it should not now be looked at. but it was not called out in their comments.
Do you recall any other matters, any other cases where we've seen that proposed?
I don't recall seeing a situation where the right-of-way width and the pavement width were one and the same. I remember most circumstances where the right-of-way width was wider than the pavement width to provide for what Gene talks about, snow storage.
Yeah.
Could I respond to that?
Sure.
Bob Smart here.
Sure, Bob.
You know, the Mwr Road a subdivision and residential compound. The board decision, and I can send the board a copy of the decision, or at least the pertinent section if that's what you'd like, indicates that the relief granted was a 20-foot paved and 20-foot right-of-way.
If you know, or if you recall, Bob, were there any peculiarities of that subdivision that made that appropriate?
I don't know. I can't speak to that. I was not involved with it. It was some time ago that was granted.
Okay. Okay. All right. Well, here's what I'm going to propose, unless I hear any objections. I'm going to propose that we continue this hearing until our next meeting, give all our members time for further study, give the applicant time to prepare responses to the various questions that you've heard. And I think,
Chairman,
yes,
Mr.
please.
Chairman, could I respond to that?
Sure.
There are members of the public, I assume, that have been waiting to speak for.
Fair enough.
For several hours. It seems to me they ought to have an opportunity.
Fair enough. You're absolutely right, Bob. I agree with you.
Yes.
So before I'm going to continue my my process with the expectation we will be continuing the hearing, but for those who have been waiting to participate, particularly those who may not be able to join us in the next meeting.
Mr. Chairman, could I just say one thing about the date? Doing this at our next meeting would be difficult. We have 2 public hearings already scheduled for that evening. I think this would need to be continued to the second meeting in July on the 21st.
Which would be more than a month away.
That's correct.
Okay. Well, having heard that, let me turn to my list of attendees that I'm looking at here and see who among those attendees may be interested in giving us their comment right now. If so, please press the raise hand button and I'll be happy to recognize you. Other than Alex and Clay who are listed, I think there are 1, 2, 3, 4, 5 others. I see one hand up. Any of the others? Okay, the only attendee I see with a hand up is by the name of Simeon. I'd be happy to recognize Simeon. Please begin by giving us your full name and address, and I'm going to ask you to limit your comments to three minutes. Thank you.
Thank you so much. It's Simeon Bruner. I am the manager for the abutting property at 700 Chestnut Street. Let me first say that it's not clear to us that we got proper notice. I don't recall getting the notice of the meeting, but my concerns, without going into detail, are simply that we expect to add 2 more lots to Heather Lane, and we'd like to simply make sure that the waivers that are granted would leave us enough access for those 2 lots in the first instance. Secondly, we're concerned about which trees are being removed, because clearly that affects our lots. And then thirdly, we'd like to make sure that there's not too much spillage of light onto the abutting property. I think those are our 3 major concerns.
All right, sir. Thank you. Have you had an opportunity to speak to Mr. Persiak or Mr. Smart or Mr. Kelly about your three issues?
We got a call yesterday morning to talk about the issues, and we did not really reach any conclusion on those.
Okay. Well, this continuance that we're going to put in place till July 21 should give you time to consult with the applicant and try to deal with your three concerns. Hopefully you'll be interested and willing to engage the applicant, and hopefully that goes both ways.
We are available.
Thank you. Bob, I assume you're available too.
We're happy to do that, and I guess I would request that we be told who to contact, because we've been trying to speak mostly with this gentleman's partner, Mr. Brown, for months, and we'd be very happy to either sit down and meet or talk on the telephone or do it by Zoom. We're happy to talk. So I'd like to know who to contact and how to contact them.
You can contact Mr. Brown, or you can contact me, and we can set up a Zoom meeting.
Would you send me your contact information?
Certainly.
Okay, thank you.
Okay. I'll leave it to, do you have Mr. Smart's email and or phone number?
I've got his letters to the board, which can probably get me his information.
Okay, great. Thank you very much. Okay, before I leave this, do any of the other attendees want to be recognized? I'm seeing a hand from someone named Kevin. Again, would you please start with your full name and address, and please limit your comments to 3 minutes.
Sure. My name is Kevin J. I'm one of the abutters to Heather Lane, or the proposed Heather Lane. I just wanted to voice my support for the plans Bill Piersack has put in place. And I want to note that the rural character is actually pretty important for this area, and any plans of his that help mitigate tree removal, which I understand the existing proposal for the 20-foot right-of-way, rather, I guess it's 40-foot right-of-way and 20-foot pavement would help to do, would certainly be appreciated by us.
All right.
I also want to state that the road in general is going to be much nicer than it is right now. I think you could see that pretty clearly from the pictures. And at the moment, living at the end of the lane, I really don't see any problem with drainage. We've never had a problem with snow removal either.
Okay, thank you. Okay, I'm just going to give a moment to see if anyone else would like to be recognized. I'm not seeing any hands. Okay, unless there's an objection from any member of the board, I am going to propose that we continue this matter till the meeting on July 21. Do I hear any objection to that?
I was going to suggest 7:15.
At 7:15. Okay, do we need to vote on that, Lee?
Yes.
Then I second the motion.
All right, discussion? All in favor? I'm going to call the roll. Paul?
Aye.
Ted?
Aye.
Jean?
Aye.
Adam?
Aye.
And I also would vote aye. All right, well, thank you very much for the presentation, and we will reconvene on this matter on July 21 at 7:15. And I do invite Bob and Simeon. I didn't get Simeon's last name. I apologize. I do hope that you'll have an opportunity to get together and try to deal with those three issues.
We will.
Thank you. Okay, that's our public hearings for tonight. The next item is minutes. Do we have, I think we have some minutes. We have one new set and we have one marked up set.
Yes, so on the markups, we have April 15th and May 5th.
We have two. I'm sorry. Go ahead. Yeah.
And I sent PDFs of with some handwritten changes today. So those will presumably be before us in revised form. And of course, if others may want to do the same.
Let me just ask, can those two sets of minutes be voted on at the next meeting, or do we need to deal with them tonight?
No, that's the idea. Next meeting.
Next meeting. Okay.
Next meeting on those.
And as to the May 5th meeting notice?
On the April, excuse me, on the April 7th minutes, we're almost there. So I'm thinking we can accept them. There's one change I put in an email today, but I guess it wasn't quite understood. I should have just written the whole sentence out again. In the fourth paragraph, it now under Mwra Grover, it now says the proposed new building is within the allowed setbacks, height limit, and parking will be behind. What it should say is the proposed new building is within the allowed setbacks and height limit, comma, and parking will be behind.
Right.
That's the only change. So if I will move that we accept the minutes of April 7, 2020 with that one minor change.
Second.
We have a motion and second. Discussion? All in? Yes, Adam.
Odd question.
Sure.
If I was not a member of the board at the time of those meetings, should I not vote?
Yeah,
on
I think you should not vote.
Okay.
Right.
I'm not voting.
Okay. So we have a motion and a second. Discussion? Questions? All in favor? Ted?
Aye.
Jean?
Aye.
Paul?
Aye.
And I'm an aye. And Adam's not voting. Okay. Further? Is that all the minutes, Jean?
That's it.
Okay. Okay. That's our agenda item number 5. Correspondence. Is there any correspondence? Lee?
I think we're fine on that.
Okay. Any reports? We'll begin with Lee.
I would just like to say that Marty and I continue to participate with this downtown working group, looking for strategies to, assist businesses in reopening and ways of providing outdoor seating for restaurants. We're meeting now on a weekly basis, and tomorrow we're going to be talking with some of the businesses in the block along Great Plain Avenue where Sweet Basil is located, to look at strategies to provide for some outdoor seating opportunities there. Also, this past week, I participated in the first round of interviews for the position of Economic Development Director. And we have, I think, one more interview to do as part of that first round, and then it's going to be advanced to a second round set of interviews. So we hope to be able to find a good candidate sometime within the next month. And I will say, and I think Adam participated in the first round, we've had some very good candidates. So I think we're going to come up with a very good end result. And that's all I really have to report at this point.
Great. Let me just ask a question before I go to Adam. Lee, do I understand from some emails I got from Marianne that we actually have 2 meetings tomorrow, one at 8 and one at noon?
Yes, that's correct. I think she has a normal working group meeting in the morning, and then Sandy has facilitated a meeting with the businesses in the affected block, I think, to get some comments from them and responses to some of the strategies that we've been working on.
Okay, great. Adam?
Yes, just following. Oh, am I muted?
No, you're good.
Very good. I apologize. Lee, just following up on your point about what the town is doing to help not just reopen restaurants but other retail. I have a note from one of the members of the CEA, who is a retailer in town, who with some other retailers, I think have expressed some concern about allowing sidewalk seating, which may interfere with access or the ability for other non-restaurant commercial retailers really to conduct their business. So I wanted you to be aware of it. I just was looking at the text during this meeting. I don't have a full understanding of their objection other than what I've just said. And yet I know that the town is working really hard to be able to ease some of these restrictions. So I intend to speak with that person, and then I'm happy to summarize in an email send to you or or Marty, or to call you both and share what those reservations are, because I want to make sure that we have to balance. It's not just the restaurants, but it's also the other retailers.
No question, that's true, Adam. And we are very concerned about not just the restaurants. We want to see what we can do to help everybody. But I'm curious as to whether the concern is a sort of a general concern, or whether there's a specific location or two that somebody's worried about.
So this would be between the block between, I think, Pickering and then Highland. So between Closet Exchange and Santander Bank.
But there's no restaurants on that side, though.
I need to understand more. That's true. I need to understand more fully what the concern is. I'm literally half reading it. Okay. And because I want to pay attention to the hearing, but I just noticed, I think what's happening is that in an effort to create some relief for restaurants, there may be some unintended consequences adversely affecting retail.
Well, we want to know about that.
So I'll collect more information, report back to you both.
Please. Okay, that'll be great. Okay, any other reports from anyone other than Lee? Okay, so that brings us to our last agenda item, which is our planning board reorganization. So vice chair currently is Jean. She's prepared to move to the chair.
I would be very pleased to serve. It probably will be my last opportunity to serve as chair during this term. And I'm certainly would be following in the footsteps of very, very good chairs. But I think I have the time and energy for it, and I look forward to the challenge.
Thank you, Jean. And I think Paul is prepared to move to the vice chair slot. Does this require? I'm sorry?
That's what I've been told.
Lee, does this require a vote, a motion and a vote?
Of course it requires a vote.
Okay. Do I have a motion?
I so move.
Okay. Do I have a second?
Second.
We have a second. We have discussion. All in favor, I'm going to call the roll. Adam?
Aye.
Ted?
Aye.
Jean?
Aye.
Paul?
Aye.
And I am also in favor. Okay. Do we have anything further tonight?
Well, now that I'm vice chair, I want to ask Lee, in this era of coronavirus, how are we handling the chair vice chair meetings?
We're scheduling a meeting and we're doing them by Zoom.
We are? Okay. So the three of us will meet by Zoom.
Yes.
Do we have any scheduled?
We don't have any scheduled right now, so I'll see what, you, Marty, and I have a schedule. But now that Marty's been released, we'll have to figure out a schedule that works for the two of you.
Released, I like that language. That's good.
Free again.
At last.
Yeah, I'm free at last. All right, I have a motion to adjourn.
Okay, very good.
So moved.
We have a motion, and Paul, is that a second?
Second, yep.
All right, discussion.
Hi, Alex. Nice to see you.
Hi.
All right, I'm going to quickly call the roll. All in favor? Ted?
Aye.
Adam?
Aye.
Jean?
Aye.
Paul?
Aye.
And I'm an aye. Good night, everyone. Thank you very
Good
much.
night. Sleep
Good night.
well.
Thank you.
Bye-bye.
Aye.